Mr. Chairman, I have just connected to the YouTube.
Excellent. Welcome back, everyone, to the second half of this first day of our Blockchain and Financial Technology Select Committee. We were before lunch talking about digital identity and having a discussion about some of the concepts. Before we get back into that discussion, does any committee member want to make any comments? All right, seeing none, we left off with Professor Reyes having some general points she wanted to make, so we'll start up with Professor Reyes. The floor is yours. And since we're after lunch now, please introduce yourself again. We might have a different crowd.
Sure. Hi. Thank you, Mr. Chairman, for giving me the floor. I do just have questions, more really than maybe some comments, but lots of questions. My name is Carla Reyes. I'm an assistant professor of law at Southern Methodist University, Edmond School of Law in Dallas. I still have this persistent question about the definition. I'm trying now with all my open screens here to find the red lined wording to see if I can make myself clear, because I'm not sure I did that earlier. I didn't have a lot of the background discussions to benefit my reading of this draft when I first read the draft. So what I'm saying now is based off of a read of the words, right? As I read the words of the draft, what it says to me is that I could use, so if personal digital identity means the intangible digital representation of, by, and for a natural person over which he has autonomy or dominion, and I'll get to my comments on that in a minute, and through which he intentionally communicates or acts. As I read those words, that to me could mean, just on the face of the text, anything. Right? It could mean literally any piece of my identity that's digitally represented, I could use to act in the digital world. And if that's what it's meant to say, then okay. But what happens when I read the definition together with the part about I can act through it, I could read it like this. This bill allows me to take authoritative activity through personally identifiable information. And that doesn't, it doesn't really compute. Like, I don't understand. Right? If I read it, if I just take the text the way the words are and I read it that way, I don't understand what it's supposed to do. That doesn't already happen under the law. And so because I have this persistent question, I had a feeling I was missing something, right? So I talked to Daza on the side during lunch break. And I think what I'm missing is that this is really supposed to get at having I don't know, like a house. And it goes to Ms. Kaiser's comments earlier, like a house or an account where I can store all the pieces, all the PII or other things that make up my digital identity. And from that house or account or whatever we want to call it, I can act, right? And so we talked and thought maybe what's missing is in the word even, just maybe it's not just personal digital identity as this like ethereal concept, but what we're really saying is a thing, like a personal digital identity account that you could act through. An account probably isn't the right word, might not be the right word, but I don't really have another, like in my head, that's what makes sense. But so I'm not suggesting that as the word to use, but that helps me make sense then of what this definition is and like what I'm supposed to do with the thing, right? And that might just be me, but I guess I'm offering that as a person who came to the draft with fresh eyes, as most people who use this will, right? And if I had that impression when I read it, then other people with fresh eyes might have the same reading and confusion. So that's the first sort of question or comment. It goes to the question I asked earlier, trying to make it more clear, but also a comment on like how maybe getting to what is bothering me about it a little bit. The second piece is I like the suggestion of dominion as an alternative to control. And I like it better than autonomy, I think. But I would say that either autonomy or dominion, you're gonna want to define, right? With like a definition within the definition. And I know there had been comments earlier that like we didn't want to do that. But from a drafting perspective, if I read over which he has dominion, he or she has dominion and through which she intentionally communicates or acts, then I would read them like, I don't know what dominion means. Like, as a practical matter, how do I prove out dominion, right? How do I prove that I have dominion? And that would be the thing that I would expect gets litigated to the extent there's questions about it, or right, or disputed, is whether you had dominion or not. And I just think, as much as we want to keep this like a clean definition, I suspect that whatever word you use there is going to have to be defined. Otherwise, you're inviting dispute over what it means to have autonomy or dominion over the personal digital identity. And to that end, I guess, as I read the earlier pieces under 40.30.102, it strikes me that you actually have what you mean by dominion earlier. Right, so it reads, acts taken through a personal digital identity are attributable to a natural person if they are the act of the natural person. Great. And then it says the act of the natural person might be established in any manner, including showing security procedure, right? So basically proving out that you had dominion over the thing. So it's a little bit circular insofar that you have a personal digital identity if you had dominion over it, right? And then you say you act through it if you can show that you had essentially dominion over it, right? But I suspect that this piece of like that you had security procedure, that you can prove that it was you using it, that's actually what you mean when you say you have dominion over it, that you can show it was you who used it and nobody else. And I wonder whether it might be useful to move that stuff, that language, to the dominion piece, rather than saying that's how you determine whether an act was taken or not. Because really, saying that when somebody acts through their personal digital identity, they have acted, right? That might be all that you're really trying to say, that it's an act with legal authority, and rather determining when somebody has dominion is what decides whether it's attributable or not. I don't know if I'm making sense, but that's what struck me as I read the full draft. And then the last thing is, earlier in this 40.30.102, part 2 and 3, I think, you use the term electronic record, or the term electronic record is used several times, but it's not later in the definition of personal digital identity. Rather, there it's an intangible digital representation of, which I take to be a synonym of electronic record. And I don't understand why we don't just use electronic record, particularly because it might offer good synergies that you do want with things like the Wyoming Fiduciary Access to Digital Assets Act, insofar as you want, say, on a person's death, someone to be able to take care of, for example, the aspects of their personal digital identity that continues to remain out in the world. You might want to note that would be subject to the procedures under that act, for example. Maybe you don't do it by using electronic record, because maybe there's some other reason why we ruled using that term out. But it's worth noting that you might want to connect the two, because people die, and then what happens to their personal digital identity, and maybe the Wyoming Fiduciary Access to Digital Assets law helps in that regard, but by not using electronic record, maybe you've made it so it's not an immediate crossover already. Okay, I think that's all that I had.
Thank you for this, Reyes. Any thoughts on that? First, I'll go to the committee, see if the committee has any questions. Any questions for the committee? Okay, let's go to the working group next. And before we do, I wanted to address a couple of the points. The first one is with regard to, could PII, would that be sufficient, or would anything be sufficient based on the definition? And I guess the kind of question I would have is what's wrong with it being what's wrong with it being sufficient? I guess I'll just throw that out there as a challenge or a concern. So let's say arbitrarily that I had personally identifiable information. That's an intangible representation of by. It would have to be of me by me. So it has to be something that I inspired, and then the representation for me at that point, over which I have dominion. So it's got to be some aspect of my personally identifiable information over which I do have control at that point, the control in the looser term concept, and through which I intentionally act or communicate. So if it is a piece of personally identifiable information and I act or communicate, and therefore it meets every one of the components of this definition, what's the downside to that being included in the definition? Because I kind of feel like, yeah, that's what we mean. So back to Professor Reyes on that. What are your thoughts on that? If it meets all of the parameters of the definition, why shouldn't it be included?
Thanks, Chairman. I actually would answer the question with a question. If that's true, then why do we need this draft? Right? Because there's a whole lot of other law that allows me to do stuff with pieces of my personally identifiable information that doesn't require that you can't create another bill that says I can do that. Right. And in fact, if that's all this is, it may be contradicting other laws, including those at the federal level. Right. So that's where that concern comes from. If that's true, I don't think you need this. I don't understand what it does that's new.
Right. Okay. If that's the only concern, then I think that gets back to some of our other discussion about this is not the end of the bill. If that makes sense, right? You need something to build off of, which you've defined as the digital identity, and then we can imbue that digital identity with things like Ueta rights, which is what we obviously have in 102, or with personal protections or privacy and data ownership. Go ahead, Professor.
Why would you imbue it with Ueta rights? Why not just use Ueta, which would cover everything that's covered by this? I would like to be clear. I am a protect Ueta at all costs person because it's a great law. So that worries me a little bit. But the second answer is it's not just about that. Like that's the obvious one to me. But the additional one is it doesn't make sense. I mean, so I guess I just would say if all you're trying to do is say people can act electronically through their digital personal information, I think you're inviting disputes over whether you have dominion over it. What happens when you've given someone else use of part of that, right? And then they take action. Can it be attributable to you because you gave up you gave part of it to them without intending that they use it, right? Anyway, I think you're inviting disputes over whether you had dominion over your personally identifiable information and whether you used it in the way that you intended to use it.
No, I see your point, and I'll get some more thoughts on it, but I think the concept is this is not the definition itself is not any type of specific empowerment or saying you can do this, you can do that. The definition is then what will be assigned some type of clarity on exactly the questions you just said. All right. So how does a digital identity, what rights do you have with your digital identity with respect to certain aspects of it, privacy and all of the other things that were considered? Or getting back to the Ueta concept, 102 is really, and the reason it says electronic records is because it really is just a kind of a copy and paste of our Ueta, and it's the link that you suggested. Wouldn't it be nice if we had a link? Well, that's what this was supposed to do, is to make sure that it was clear that your digital identity was effectively authoritative from an action standpoint with regard to Ueta. Does that make sense?
Sorry, is that a question for me? I don't want to
Yeah.
get out of turn.
Sorry, Professor.
It makes it. No, I'm sorry. I don't really know still the procedures, so I just want to make sure. I'm not
you're fine. You're fine. Go ahead, Professor.
That makes sense what it was trying to do, but I would argue that Ueta covers it already. Like Ueta doesn't need help. I think that it says if you sign something electronically, it counts, and it doesn't say how you have to sign it electronically.
Right. And Professor, I'd say that's probably true. And the intent of this is just the clarity that, yes, it is true, if that makes sense. Something that we often do through statutory languages in case there was any doubt, does your digital identity work from an authoritative standpoint as an electronic signature? Yes, that's what these things say. Go ahead, Professor.
So the concern from the Ueta side then is that whatever's not a personal digital identity then is carved out, right? So every time, well, but that's how Ueta gets interpreted, right? So every time someone clarifies Ueta, what they've accidentally done is whatever is not in the clarification, but meets the clarification's definition is now outside the scope of Ueta. And that would be the strong, very strong concern.
Well, if we do that, I think that is a concern. This is not changing the Ueta itself. This is basically saying that an action taken, as you see in the language, an action taken in accordance with this through a digital identity shall be attributable to the organization or the individual. So the intent is to achieve that. If there's a better way for us to get that language in section 102, if there is a possibility of that being viewed as a carve out and therefore excluding others, I do think we need to address that. So with that, Daza.
Thank you. Senator Rothfuss and members of the select committee and those testifying. So firstly, let me just say, I find Professor Reyes' comments and questions entirely helpful because this is somewhat new type of legislation, and looking at it from as many angles as possible, and always asking the existential question, is this needed? Does it do what we thought it was supposed to do? Would it be interpreted differently? Is exactly what's needed now. So I'm just very thankful for that, and also for the opportunity to speak offline during the lunch period. Just to reiterate a couple of the things that came up in terms of the potential confusion with the current wording, and this train of thought of is this about personally identifiable information, PII? And so the main point of view I want to share on that is I don't believe this is intended to be about PII alone. The information like our like whatever, like the name, serial number, address, on and on, location history. This is very important information, and it's the type of information that is that like, let's say, emanates from and ought to be able to be controlled by a person, and that person increasingly is operating in and through cyberspace. We don't really have a pointer for that right now, and there's a lot of blur between that person operating and all of the distortions that can happen when we're operating through another entity that's provided our identity and a bunch of other contracts and functions around it that are really in their interests and not reflecting and supporting our own. And so that's one thing. And then the main thing with the confusion is, if I were to replace identity with the word personally identifiable information, which apparently is a reading of this because it was Professor Ray's reading, I don't think this would parse. It doesn't make sense to I mean, I guess you could come up with cases where you sort of communicated through a personally identifiable information because it included a statement, but it doesn't make sense to me. What makes more sense is the word that came up when we were talking informally. I suggested to Professor Ray's that what I think this is more about would be more closely akin to an account than to data that you would have in or associated with an account. So when you kind of like spin up a Unix machine or something, or any application, and create an account that you act through, that you authorize things through, that you communicate through, send and receive email or messaging, that you may have a profile page that you can use to log into other systems. That's very common nowadays. That you use to maybe send or receive legal notice or provide an oath or affirmation or that you could use to authorize or revoke authorization, or the big one, but I'll put it last, is, you know, signed, like a signature. I have nothing against things like DocuSign or other services that help us, Adobe. Like, I work with many of these companies, they provide fine services. Something is missing, however, especially with something as sensitive as a signature or the making of oaths and affirmations, providing consent, or at least philosophically, the consent to be governed itself, the one underlying all others. There ought to be some place or some way where people can do that in their own capacity, through their own, by their own lights, through their own methods and mechanisms, untainted or undistorted, or even raising the question of what other things may be happening behind the scenes when it's intermediated through another, especially when that other is the party that you're transacting with and providing you your identity. And now we come to the use cases. So I was at every Ueta drafting session. I love Ueta, and nothing, I agree with Professor Ray's, like, never tamper with Ueta intentionally or unintentionally. And I think there's ways to draft around that. I do think extending and building on Ueta can be just fine, and maybe some further clarifying language, like in line with, you know, this section of Ueta, but not to be interpreted to in any way whatever diminish its application, or what some language that can be come up with may in fact be appropriate. But the main thing is, in Ueta, the committee and those of us that were helping decided that it ought to be limited to basically commerce and business for the most part. That's its application. But a lot of our lives is not commerce and business. You know, we exist in society, we exist in the body politic, we exist in, you know, home and family. And a lot of this is now happening online, you know, especially during the pandemic, but just in general, that's the change. And so Ueta doesn't quite cover that, and it doesn't really cover these public sector things either. And so I would just suggest that perhaps there is a word missing here, so that, I don't know whether the word account is the right word. I think it may have other baggage with it, perhaps, but the idea of an account that you act through, that you communicate through, that could operate, that could use SMPT for email, that you could route messages to and from for messaging, that you could have a profile with, some of the other functions that you could authorize, log in to do something with the state or with others. Maybe there's some word there along those lines that is missing, that could clear up the fundamental questions that Professor Reyes is asking. So those are my comments.
Thank you, Mr. Greenwood. Let's go to Ms. Kaiser. Go ahead.
Thank you so much. I'm so glad we decided to, you know, go deeper into what additional definitions we might need in order to make this law more clear and useful. That was something we discussed in our working group yesterday, and also something that we came to in our working group on data trust, and we'll be able to discuss that in the next session. But that we probably need more definitions of personal data or PII to be used in this type of legislation in order to make it more powerful. I definitely see that as a trend at the federal level and in some other states where laws that relate to the use of technology are becoming more technical. So while I love everything that this piece of legislation defines thus far, the fact remains that a digital identity is a collection of personally identifiable information. That's what it is, and that's how you authenticate. So making sure that we have something like that in there, and whether we come to the definition of personal data, which, you know, in our September session of the standing committee was when it was first suggested that a subcommittee on personal data definitions be created, specifically with Professor Reyes and I joining. And instead, actually, we ended up joining the digital identity working group and a working group on personal data trusts, but not actually going to define personal data, which still needs to be done, actually. And so I'd like to put that on the record, that that's something that we should probably concentrate on, because it would be helpful for both of these working groups and for the legislation that we're developing to be stronger and more, again, technical, because we're talking about the use of technology. And I think the more technical laws like this become, the more enforceable, the more sense that they end up making. and the less challenges that will actually come up. So when we're thinking about what we could possibly add to this, I do believe that a personal data definition and uses of personally identifiable information as the technical makeup of what your digital identity is do need to be included for it to have more teeth and for it to make more sense in terms of technical enforceability for companies, for violations, for negligence, and what have you. And I think it's important to also mention that it really feels like what we're trying to do with this, or what a lot of us hopefully would see in the future, is that we can use our digital identity to protect certain very valuable, personally identifiable data sets, right? And that we would be able to use a digital identity solution to make sure that that personal data was never transferred to anyone and could not be sold and could not become someone else's property or a commodity, that it is more intrinsically a representation of our human self. And that is why we are going through the process of defining this in the first place, because in the future, we would like for these data sets that make up our digital identity to never be transferred and therefore to not ever be abused. Right now, our digital identity is sitting in millions of databases around the world, and that's why so many people have issues with fraud. And so that's, I think, where we're trying to get to, is saying that the data sets that make up our digital identity need to be protected in a particular way and need to have more of a, natural law or human rights protection, as opposed to a lot of the other commercially viable data sets that we create that could be linked back to our digital identity, but don't make up our digital identity. So I think that's worth us debating and kind of, getting further into. Doesn't need to be in this session, but I definitely think we should take offline the personal data definitions and PII further, so that we can get bills drafted on that and then use those definitions going forward. Thank you.
Thanks, Ms. Kaiser. And I think that's a really sound approach. The idea of adding some clarity through consideration of additional topics like personal data, personally identifiable information, those things, and using it to build a construct that refers back, perhaps in Section 103 or wherever we place such a thing, so that it strengthens and clarifies some of the things that might not be unambiguous from the definition. Thank you. I'm going to go to Representative Lindholm from the committee first, and then we'll get to others. Go ahead, Representative Lindholm, questions?
Yeah, thank you, Mr. Chairman. Ms. Kaiser, thank you for volunteering and helping us out in this task. As you know, you've been around us for the last couple of years. Digital identity has been one of those topics that we keep going back to. And the reason why we keep going back to it is because we know it's going to be damn important. We just don't know how the application is going to look that's going to be the most advantageous for the state of Wyoming. Well, Ms. Kaiser, I'm going to be tough on you now. I don't see that this bill does a damn thing. Tell me it does. Tell me how it does it. Because as it stands right now, I've read through this thing several times and I keep trying to understand the problem that we're fixing that's going to be an economic development hurdle for the state of Wyoming that's knocked over. And I'm just not seeing it. I'm not reading into that bill. What are we tackling right now? Where's the pain point?
Ms. Kaiser, go ahead, respond.
Of course. Well, the number one thing that I see is the opportunity for the hundreds or maybe thousands of companies that are digital identity solutions that are legal entities elsewhere in the world to want to move to Wyoming, because it would be the only place where your digital identity is legally protected. So I see that as a huge opportunity. And more specifically, I think what we're trying to do with this bill, which I agree with a lot of people that it's not ready yet, but would be to protect those personally identifiable data sets that make up your digital identity in a way that is not protected elsewhere. And therefore, the companies that were operating in Wyoming and are supposed to be protecting those data sets as their business model, coming to the state of Wyoming would be a distinct commercial advantage for them and be more attractive to consumers. This is kind of a similar way that I'm looking at the the possible data trust entity that we're discussing in the next session as well. But I really believe that due to the amount of digital identity companies and solutions that are being built in the United States and around the world, particularly in the blockchain and distributed ledger sector, that finding a way to have special protections for that in Wyoming does give a distinct competitive advantage to the state.
Thank you, Ms. Kaiser. And Representative Lindholm, I'll go right back to you, but respond briefly. If this bill, as it's drafted right now, were the end of the game, then you'd be right. It wouldn't do anything. It's not the end of the game, though. It's a piece in what we've determined to be a gigantic puzzle. And it's a necessary piece to get right. And the thought here is if we try and tackle every piece at the same time, that's going to be a heck of a challenge from a legislating standpoint. So the hope with this so far is it's a heck of a challenge to even get a rational definition of digital identity, personal and organizational digital identity in place, which is what we've been doing all day and what this working group has spent a tremendous amount of time on. When you can get to something that you can start hanging other operations on, that's where the value is. It really is. So it's not until you get to what Ms. Kaiser just described that anyone's going to say, ooh, we need to go to Wyoming. If this is the end, really, if this is end of game, nobody's coming to Wyoming. But it's a necessary step to get to the end of the game, is the way that I see it. And I'd like to, I wish there were a lot more meat that we could add to it right now. But again, until we get this figured out, I don't know how we add, GDPR and CCPA just started without this. We're trying to start with the concept and then build some of the core functionality of CCPA and GDPR in a way that reflects that and that makes this unique and brings the most value to the table. So it's not a standalone piece of legislation. It's a piece in a larger puzzle, which gets at the data trusts concept. It gets into some of the other things we've been talking about with corporate registration and ease of transaction and relationships between individuals and organizations through digital contracts and through all of the other interactions that we want to enable. But it has to start with the concept of having an authoritative legal representation of your digital identity, whether that's an organization or a person. And so with that little bit of context, back to you, Representative Lindholm.
Thank you, Mr. Chairman. Yeah, and I appreciate the explanation that, with some bolt-ons, this could be great. Tennessee thought the same thing when they defined secure contract. And they're not even close in the race anymore. They're not even trying to be in the race anymore because they defined secure contract under what they currently understood to be a secure contract. Now, obviously that changed over time, and certainly I don't think this is probably that radical of an aspect to try to define. But Mr. Chairman, unless I hear some pretty profound evidence on why this is needed now without those bolt-ons, I hesitate because I don't want us to look like Tennessee in regards to digital identity. And that's my concern here. I haven't, and Ms. Kaiser, I super appreciate you. Out of all the testimony I've heard, it's fantastic. Everybody did a great job. And I know the working group worked real hard on this, but I would throw out that caution that without a bolt-on attached to it, there are negative consequences that we will face. And I don't know what those look like. Nobody really does until you get there. Just caution, I guess.
Absolutely. Thanks, Representative Lindholm. And on that point, what the working group is working on right now and is what are those first three, we'll say, bolt-ons, as you referred to them as? What are the three principles or concepts? And maybe it's not three, maybe it's four, maybe it's two, that need to be added to provide the most immediate value and again, help to clarify. So it's a challenge, and you know this legislatively, This is complicated, and it's a challenge to bite off several different concepts in the same piece of legislation and get people to understand all of them independently. Maybe sometimes that's a blessing instead of a curse. But the idea here is really to try and focus on these definitions to the point where it would enable those bolt-ons while contemplating those bolt-ons at the same time. And if you think it's better and stronger if we've got those concepts built into it, like the attribution, the portability, fundamental privacies, some of the types of things that go into the self-sovereign digital identity, that might well be the right way to do it, is to bring some of those along right from the beginning, to clearly demonstrate that value. But that's certainly a lot of additional work, and we're not afraid of that work. But I think it's just important to note that that's part of a process. All right. Any other question or any other questions, Representative Lindholm? Do you have anything else? Any follow up on that for now before we go to others? Okay. Well, let's try and be succinct in comments a little bit moving forward, because we are again a bit behind. But Mr. Allen, I want to go to you.
Thank you. Thank you, Chairman Rothfuss and committee. So I wanted to respond both to some things from Carla and Brittany in the previous thing, but also to Representative Lindholm's challenge of why is this relevant now. So I'm going to do them roughly in that order. So I think Carla and Brittany both are very concerned about its connection to personal identifiable information. And then personal data, which sometimes is and sometimes isn't personal identifiable information. But for me, that's not what this paragraph is about. This paragraph is about the ineffable party that can make a decision. Okay, it's the actions to decide to make an action. And my take would be that much of the personal information, personal identifiable information and personal data does not have proper provenance back to the Dominion. So if you perfect the title of this stuff, you go back to somebody who owns it, but behind somebody who owns it is the Dominion, which is the perfect control. That's in the case of property, that's the state or the country or whatever. But there is a title that goes all the way back. Yes, you may own this piece of land, but in the end, really, the perfect control is beyond that ownership, is in the sovereign country or whatever that owns that. Well, the same thing kind of happens in the data world. We have these different parties who are making claims about stuff that they do not have not been given the proper rights to, that you can't attribute back. And then when we try to make certain kinds of actions and decisions on things, this sort of goes to Representative Lindholm's, parties are trying to have us be under Coinbase for having custody of our digital assets, or having Facebook manage all of our logins, or Google in the case of Google Gov with Wyoming. Every at any point, they may be violating a contract, but they can basically shut down the Wyoming government, who exclusively uses it for identity of Wyoming employees. So we're trying to establish a more firm basis for that. And this directly applies to, another bill that we're considering right now, which hasn't been mentioned by the other people, which is the protection of private keys. Because, that is the best way to assert dominion in a virtual world, is through private keys. And from that, you can control identity, assets, and control your actions, and be able to prove your acts are voluntary and things of that, rather than Facebook or DocuSign saying, well, we think you signed it, and here's some things why we think you signed it. But private keys is the best way to do perfect control. So I would really like to see us, not forget that what we're really talking about in the same way with what, identity is and, cognito ergo sum and whatever that's hard to define. But the bottom line is my cognito ergo sum in the real world allows me to take actions, make decisions, do things, decide to enter or leave a room or whatever. But when we do this online, it ends up being, well, Google, decided you have the right to be able to do something within their system or whatever. And we've got to get beyond that. We have to be able to say that, no, there's some fundamental things. I have a right to be able to business online. I have a right to be able to communicate online. I have a right for all of this. And thus we need a definition that says, hey, there is this thing that can authorize, that can act, and by those actions can, may need to be proofed that they are the party with personal identifiable information. But the personal identifiable information is not the identity. It is just simply a way of connecting to the identity. So I want to bring it back to acts and actions and choices and dominion. So thank you.
Excellent. Thank you, Mr. Allen. Briefly, Professor Reyes, and then we might have some general public comment. I think we do. I want to get to that, but go ahead and a quick response, Professor.
So just, Mr. Allen, I don't disagree with the baseline there. My comments are more that I don't think the words in the paper say what you just said, right? And I know that it's a working draft, but that's the baseline point is that's not what the paper says. But also now I have a new question. Is it the intent that this digital identity eventually will somehow interfere with Google and Facebook contracts? Because that's not a thing I think that can happen actually in law, right? So like if I agree to the Facebook terms of use, they can still do what they do under the terms of use. And the fact that I have a personal digital identity doesn't interfere with that in any way, shape, or form. So I still struggle a little bit with the connection between the existence of a personal digital identity made up of whatever PII it is and solving the sort of Facebook, Google access problem, unless and until it's connected to the data trust stuff that Ms. Kaiser talks about a lot, right? But I just want to be clear that my comments and questions are all generated from the words on the paper and the fact that I don't understand how they connect to the things often that I hear said out loud in these discussions.
Great. Thank you, Professor. All right. Let's see if there's any other public comment. I think we have Mr. Steve LeMay, if I'm not mistaken, is here. Yes. If he could join.
Yes, thank you. Can you hear me okay?
We can hear you. We can't see you. I don't know if you have video available. If not, that's fine.
I do. I'll turn it on. Thank you very much. First of all, I'm real excited to be a part of this. You guys are way ahead of the curve. I'm an IT consultant in the Seattle area, working for the usual suspects in town: Microsoft, Starbucks, the Gates Foundation. Data privacy expert, been involved in the blockchain and digital identities now recently for the last few years. We're standing up services and we're really excited actually to get to Wyoming as well. We just stood up our LLC, gonna apply for an SPDI license and provide all sorts of services. And one effort that we're doing here that I'm trying to do actually is partner with the state. They're trying to pass data privacy legislation and there's a little bit of discussion on digital identities. But the main piece is, and you're having the same discussions in terms of, I guess the legalese and the aspects of, what you put into the bill. But the main challenge that they came to, which I think you're running into as well, is, what is the scope of the effort, right? Instead of a solution in search of a problem, what is the actual problem that you're trying to solve for? Is it scope around data governance? Is it protection of individual data rights? Are you going to be coupling it with data privacy laws? Things of that nature. So I would say, this kind of forum is, first of all, fantastic. I love being a part of this kind of stuff. I'm basically running away from my current Microsoft project to be here, and I'm very happy to do that because this is, quite frankly, way more important. And I would suggest really what we try to do too is set up, you're kind of doing it now, called the PPPs, the public-private partnerships, where, you really sit down and look at, what are the real solutions that you're trying to solve for, actual examples in terms of, data breaches, breaks, what's happening, and what sort of technology you can, sort of put around that to solve for it. And we're really trying to work with legislators like yourself to come up with what we call, or I'm trying to promote, as a win-win-win solution, right? It's not enough just to pass legislation as it relates to either data privacy or even digital identity components. You need to really come up with a framework and a technology platform that enables your citizens to take advantage of that, as well as you, the government, to track compliance around that as it relates to those businesses, and have a platform that you can deliver to those businesses to say, look, yes, you can go build your own. It's the typical build versus buy decision, or you can, leverage our platform, which, gets you automatically compliant. And, so there's aspects like that you need to sort of think about. And there's always great interaction you can have with, maybe folks like myself and others. But I would say that, look at real world examples of challenges that you're, trying to solve, and see where the technology can solve for that. Don't try and boil the ocean, just take it bit by bit and, work through it also from a legislative standpoint. Would it be okay if I share my screen just for a second? Or
yeah, very, very briefly, because we are behind, but if you've just got one quick slide or something for us.
Definitely, yeah. So this is, sort of the services we provide. And this is a real world example, by the way, of what's happening in the state of Oregon. They have concerns around citizens who are applying for a gun license, for example, and they're worried that, this cross sharing of data across these hundreds of different, departments in the state, when it goes to the Department of Health and Human Services, because they have to check their mental history, they get blocked for other services as well, because that background check leaked into there, and, they're not getting rid of that data. So this is a real world example around, using digital identities, which is, we have that technology, to, house that request into a smart contract. You have separate smart contracts, that house those data points as it relates to that interaction, and it stays within that channel. It goes to the right folks, it stays with them, and then it gets dropped after that. And so that's just a typical example. And then, that's a micro example. You have a much more macro example around, how you couple that with your laws, right? As far as, I want to request a copy of my data. I want, first right of refusal, all of that sort of element. You have, of course, teeth, that are nice and sharp, because it's, your digital identities are backed by those data privacy statutes, and those are hard coded into digital identities. And then, it can be tracked throughout the process there as well. And that'll help you with, compliance and all that sort of thing. So,
Great.
So anyway, I know I threw a lot at you there, I'm sorry, but I'm just, super excited to, be a part of this. And man, I just wish you guys were here in Washington State. But it is a challenge. I would say, look at the solutions, make a short list, right? What are the most important aspects that you want to cover from a real world, those real use cases and those scenarios, both for you, the government, and for individual citizens? What are you trying to do for them? And then look towards those solutions.
Great. Thank you, Mr. LeMay. Any questions for Mr. LeMay? Any questions from the committee? Seeing none, thank you very much. Appreciate your presentation and your participation, and we look forward to working with you in the future.
Yes, thank you. Me as well.
Take care. All right, Mary Beth, do we have any other public comment?
Mr. Chairman, I do not have anyone else on my list.
Okay, excellent. All right, so back to the legislation, and any other final comments before we just move back to the committee? Any of the folks on the task force? Very, very brief final thoughts, like 30-second synopsis would be great if you have any. Go ahead, Deza, 30 seconds.
I would like to suggest that the working group take Representative Lindholm up on the challenge to include at least one in those applications of the definition of digital identity, at least one thing that, if successful, would materially advance economic development in the state of Wyoming.
Thank you. Any other thoughts? Go ahead, Mr. Diedrich, 30 seconds.
I would like to second fully what you, Mr. Chairman, said, and Steve LeMay said, that the homework of spelling out the actual use cases, and I would say even all of them, should be done first before getting back to defining digital identity, because it is so important.
Thank you, Henning. Any other final points, final thoughts? Seeing none, public testimony is closed. Thank you, everyone. To the committee. So there's a couple of things we can do. We don't have another meeting in this legislative session. So we have to, whatever we do for final action would be today. We certainly don't have the capacity to amend in some of these awesome use cases that we've been discussing, but that doesn't mean this is the end of the game in terms of development of this legislation. As we talked about early on, there's a likelihood that we'll really just continue our work in the next legislative session with basically the same cast of characters. And so continuing work makes a lot of sense. But the question then for the committee is, the bill is in good form right now. It just doesn't do as much as we want it to do. We'd probably want to make a change and add the word dominion where appropriate. We heard a better example there. So the question to the committee then is, do we want to pass this legislation in its current form so that we have this as a vehicle or a tool if we do end up going into a legislative session with the 65th legislature as it stands now, and then we can still work through the amendment process, we can add things? Or do we just want to set this one down for now and then continue work on it until what would effectively be a 66th legislature action? And I'll just leave that open to see if there's a motion, any thoughts, anything else. Yep, Senator Dockstader, go ahead.
Why not put it in as a placeholder? Just have it there. We don't necessarily have to move it forward, but have a placeholder.
Okay. I think that makes a lot of sense. And that would basically just be running past the legislation with the one change, and we'd have it as a placeholder. Other thoughts? Go ahead. Representative Lindholm, thoughts?
Yeah, thank you, Mr. Chairman. And to Senator Dockstader's point, I mean, I think that's a solid plan. I don't think anybody agrees with that, or anybody's on board saying the bill's, good as it stands right now, or as good as it's going to get. We all recognize there needs to be some more work done. But we've certainly done that in the past, where we've passed forward legislation knowing we had to get it fixed. And the only thing I would extract on that is, whenever we've done that in the past, we've extracted a promise from the chairman that they kill it if they can't get her done.
Yeah, absolutely. And I have no reservation for that. I'm sure Co-Chairman Olson feels the same. If we want more work, and it sounds very clearly that we want more work on this, then we'll make sure that happens. And honestly, the working group has continued working beyond this draft. They're already doing it. So I don't see why they would stop right now, since they're all heavily engaged in this and have invested so much time already in gathering the expertise to do it. So thank you, Representative Lindholm. Any further thoughts? All right, that being the case, I'd entertain a motion on the legislation. All right, Representative Lindholm has moved it. Is there a second? Got a second from Senator Dockstader. Amendments on page 1, seeing none. Amendments on page 2, seeing none. Amendments on page 3, seeing none. Amendments on page 4. Let's at least get that one done. Senator Nethercott.
I'm not doing the amendment I think that you wanted, but wanted to talk about the term dominion, and if we wanted to put it in so we don't forget about this placeholder in 4 months, 5 months.
Yep, that was actually Senator. That was the precise amendment I was mentioning. Yep.
Well, I'm brilliant then. Yeah, so I'll make that motion that we add that language in where indicated to state on line 7. So it would read person over which he has dominion.
Yes.
And dominion and that's it. Strike the rest.
I think over which he has dominion and through which he intentionally communicates or acts his desire to stay there was the discussion. It's just replacing autonomy with dominion was the discussion of that particular improvement, both on that line and 16.
Do we need through which? Is through which he? Is that too much words? I like to get rid of the he's and the hers if they're not necessary. And isn't it automatically just inherent in the language if you intentionally communicate that you're doing it?
Not according to the several hours of discussion that surrounded that clause.
Well, I don't want to undo that. So let's just go ahead and undo that accordingly. We're just replacing the word autonomy with dominion.
Okay, we've got a motion. Is there a second? Got a motion and a second by Representative Lindholm. Any discussion on the amendment? Seeing none, all those in favor by a show of hands? Any opposed? Seeing none, that motion carries unanimously. Any further amendments on page 4? Seeing none, any discussion on the bill before we take a roll call? Seeing none, roll call vote, please.
Mr. Chairman, this is a roll call vote on 21 LSO 216 version 6 as amended. Senator Dockstader.
Aye.
Senator Driscoll.
Aye.
Senator Nethercott.
Aye.
Representative Greer.
Excused, and we'll hold it open for him.
Representative Lindholm.
Aye.
Representative Yin.
Aye.
Co-Chairman Olson.
Aye.
Co-Chairman Rothfuss.
Aye. Thanks, and we'll look for Representative Greer's next appearance. So to the folks that have been engaged in this as participants in the working group, I think you heard the direction of the committee that we've got a number of things that we need to improve. We need to clarify Professor Reyes's concerns so that the language more closely aligns to what we want it to do. We need to make sure that we've got some of the surrounding material that implements and provides value to this, specifically with regard to applications and use cases, as Mr. Dietrich mentioned and Mr. LeMay outlined. So ensure that we're doing the things that we want to do. And Ms. Kaiser, I think, has a clear handle on a number of those interests, as well as the principles that of sovereign identity that Mr. Allen has put together. So we'll figure out what the best 3, 4, 2, whatever the case may be, of those that move us down the road, the low-hanging fruit, and get those written up. All right. Anything further on that? Excellent. Thanks, everyone. Good work on that. This is it's a big lift there, and we've got literally the world's best people working on it. So I think we're in good hands. And when they all agree it's a good bill, I'm confident it's going to be a good bill. All right. Next on the agenda, just a short couple of minutes behind, data trusts, but I'm confident that Representative Yin and this working group will undoubtedly help to catch us up. We'll see. Representative Yin, updates on data trusts, and we do have a few folks that are interested in weighing in on that also, but let's once again try and be concise and tell me about the work from the working group. Representative Yin.
Thank you, Mr. Chairman. So the working group did meet. We discussed the concept of data trust and what it would really mean or what it would also require. And I think that's what the sticking point was and why we didn't bring forth any legislative drafts today, is because it may be premature to have data trusts without any sort of data privacy laws, because if there is no teeth in the way that you protect your data, if we want to try to consider data as property, for example, then the property ends up being worthless if once it goes into someone else's hands, they can do whatever they want with it, right? So without any sort of data privacy laws to protect your data or claw back your data at any point, then having a data trust becomes slightly premature. So I'm more than happy to let the other members of the working group expound on more of the discussion, but I think if they're welcome to correct me, but I think that was the general consensus
Excellent.
of the discussion.
Excellent. Thank you, Representative Yin. And we're talking before on digital identity about use case. This is a perfect use case scenario. So as we're trying to build a digital identity that has appropriate privacy protections around it and an intent of use, let's make sure that we've got a bill over there that makes this data trust conversation functional. And that can be one of our key case studies, and we might identify other ones. But I appreciate the fact that these two are obviously intimately related. Other members of the working group, and again, let's try and be concise because we have been down a lot of this road, but let's get some highlights. Professor Reyes, I saw you just popped in, so please share.
I think my comments are simply to echo those of Representative Yin. That was the general consensus from the call. I think the concern most broadly is, although recognizing this is one of the important use cases to draw business to Wyoming, it's imperative that we maintain the purpose, which is ultimately to protect the person and their data. And without the sort of infrastructure and guardrails to do that, moving forward with the data trust piece of it is premature. That's at least in my opinion.
Excellent. Thank you, Professor. Appreciate it. Ms. Kaiser, anything to add?
Yeah, absolutely. Thank you, Chairman and members of the committee and members of the working group. So just to go a little bit deeper into some of the concepts of personal data trust that we discussed, we talked about the concept of us having a specific legal entity in Wyoming that would allow a third party to be trusted with holding your data assets or your digital assets. And what would that look like? So that could be a model where a third party is protecting your personal data assets. It could be a model where that trust or whatever entity we come to agree upon could monetize those assets for you, because it could be everything from personal data that's not personally identifiable. It could be intellectual property. It could be your corporate data assets, whatever that happens to be. And because there are millions of those businesses, probably in the tens or perhaps hundreds of millions of businesses around the world that monetize your data and that hold your data on your behalf. What was quite interesting for us was to have an ethical and trusted business model that had a minimum standard of cybersecurity and data protection. And whatever those standards happen to be, there's plenty of countries around the world that do have those standards. We just haven't reached that in the United States yet. But having an entity that upheld certain standards, and instead of the traditional Wyoming trust model where you give up ownership of your assets, you would retain ownership of those assets, and they would have a fiduciary responsibility to you for either the protection or the monetization of, depending on what that decided to look like. And we all agreed that definitely in order to have an entity that is holding your personal data assets or your corporate data assets, that we definitely needed to get into personal data definitions first, and therefore data protection and privacy law before we would be able to have a third party entity that was holding those assets on your behalf. So there are a lot of different models that we talked about, a lot of different possibilities, but there's definitely a huge opportunity for that business model to be well defined. I just want to cite the case of, for instance, in the country of Sweden, they have a government cybersecurity license that you can get. And once you have that license, there's only so many companies that actually have that. It always greatly increases the value of the company and the amount of customers that you have, because you are trusted that you are upholding to certain standards, and therefore you can be trusted with the data of companies and individuals. So it's been very popular there. There are other countries that have similar models, but in Sweden specifically, which was the last place I was physically before the shutdown, the last other country besides the United States, I could see how incredibly impactful that particular license or entity had been for them. And so I'd be very interested in having something like that, especially because of the amount of companies that do third-party data processing and the fact that most individuals don't trust a lot of the biggest companies in this area. You know, if you think about Equifax, Experian, Axiom being a lot of the examples of these big data companies that hold your data on your behalf, even though you haven't consented to it, that we could have a trusted business model that would be incredibly attractive for individuals to make use of as a consumer, but also for companies to want to set up in Wyoming. And I actually have a handful of companies that said once we actually get this, a draft of this legislation, that they would come and testify and say that they would immediately apply to create one of those entities in Wyoming once we get there. So I'm pretty excited about it. I know we're in the very beginning, but I would love for us to find a way to first tackle some personal data definitions. I know I've had some great conversations with Chris Land, who actually wants me to connect you guys with the team that wrote CCPA, and I'm very happy to do that to make sure that we can integrate with the only other privacy law that exists in the United States, but we might be able to improve upon it, but to make sure that we don't, conflict, especially considering a lot of large companies are applying CCPA nationally already. We want to consider that and think about that as we go forward with those definitions. So thank you.
Thank you, Ms. Kaiser. That's a wonderful rundown. And I think one of the things that we probably need to understand maybe is what the architecture of a piece of legislation like that would look like, what the key components are, and what else we need to have in place. For example, the appropriate privacy protections, kind of a recipe for what a data trust draft bill would look like, and then what the preconditions or required foundation needs to look like, so that we can get all of that in place as well. And I think those are good next steps, even before we draft the other legislation, to ensure, as well as obviously you're absolutely right. We need to make sure that we're consistent with CCPA, so that we can honestly leverage as a state a lot of the market push that California has in getting compliance. We can obviously get compliance with CCPA. Thank you, Ms. Kaiser. And Mr. Marr, do you have any quick couple of minutes of input to add?
Yes, I do. Can everyone hear me?
Yes, we can.
Okay, great. Chairman Rolfus, committee members, my name is Brendan Marr. Quickly, I'm an MIT Media Lab alumnus from 1998 and computer scientist. I concur with Ms. Kaiser, and I'd like to embellish upon the thought about data and how we think about data and identity related to digital identity trust, digital trust. First off, the salient point is that you can't have data without thinking about the algorithms that produce that data. And as we go forward, the notion of these algorithms and how we have identity handles to those algorithms become extraordinarily important, because the information that we have is not necessarily going to exist a priori. Think about it like this: if I have a watch and it's generating real-time data, that real-time data might be my heartbeat, and it's going from my watch out into the decentralized ecosphere. It's certainly my data, it's my heartbeat, but it's not something that is this big blob of personal data that was generated at a very early point in time, like when I was born, like my name or anything like that. There's lots of data that we will be generating which is going to be real-time data, and that data is not going to be stored in a database as we currently know it. And quite frankly, this is the way things are going with many types of algorithms, including the algorithms of artificial intelligence. These are generative algorithms that will generate massive amounts of personal data because they come from myself, but they are not necessarily data points which will be stored in a database. And a salient architecture to think about, and I do want to get to answering how we go forward from here. A salient point of the architecture that has been developed over these last 10 years really has to do with a baseline architecture for the decentralized web, Web3, just like we have the HTTP protocol. There are other protocols that allow for data that we have on our phone, for example, or our watches, and to have it to go directly from those devices out, distributed out to multiple computers. So this data will actually never be in a centralized place. So what becomes really important is not to be thinking about data as this big blob that I have control over, but that what is important is a hook into the algorithms, processes, or computational constructs that generate this data. So really, data trusts are not just about data, but they're also about holding the computational processes that generate that data. Because really, my heartbeat is not something that is going to, be in some big database. It's going to be one point of information in, a massive amount of data analytics. So I'll leave you with that, and I will say finally that just one quick point. The way we get there is alphanumeric representations of keys. We define how we can define keys, then we can define both the data and its encryption, and as well the algorithms that produce and generate that data.
Excellent. Thank you, Mr. Marr. Any questions for Mr. Marr? And I actually didn't open it up for questions for Ms. Kaiser either, I don't think. So if committee, you have any questions, please chime in. All right, seeing none. Thank you very much, Mr. Marr. Joel, do you have any additional comments to add?
No, I don't. I just the one thing that I do want to suggest is that as we move forward, a lot of services that consumers, individuals are using are being provided essentially for free, but in exchange for the information or the data that's being collected. And I wouldn't want us to necessarily create such a ring fence that free flow of services in exchange for data, when you willfully do so, isn't permitted going forward because of our legal constructs.
Sure.
That's all.
Yeah, make it enabling instead of restrictive,
Yep.
unless you want it to be restrictive. Exactly.
Yeah.
Thank you, Joel. Appreciate that. Okay, we've got other general public comment. Let's keep this very short. We're not taking action today on anything from data trusts, so I really do want about a 1 minute key thought that isn't redundant. Mr. Greenwood, go ahead. What's your 1 minute?
Thank you. I believe data trusts are very important and they're missing, and legislation could be very useful to promote them so that they can be used. I would just invite the committee to look at the Open PDS or Personal Data Store project at MIT that we'd worked on in 2012 and 13 with DARPA's help to put some open source out and in some use cases. And in the years since, you can check the train of further work in research at trust.mit.edu with Opal and other emanations. In the market through civics.com, I've been working a lot with brighthehive.io, and they are a data trust company. And so if you go to brighthehive.io and just scroll down to their case studies, you can see some good examples in state government, Colorado and other places with Goodwill and their partner networks. And JDX is perhaps the most important one, in terms of economic development. That's a job exchange network between employers and workforce development authorities and people that we need to shop resumes around, and getting all of that together. You need a legal overlay and some technology and trust and governance, broadly known as data trusts or data collaborations, data co-ops, whatever. These are really important. They're taking off. Please help.
Excellent. Thank you, Mr. Greenwood. All right, Mr. Allen, 1 minute.
Yes, thank you. So I had a number of quick points. I think the key thing I'm interested in this is that we really are clear about the fiduciary responsibility here, because we need these data trusts, because I'm an expert. I'm the co-author of SSL, old legacy security, new legacy, new security such as decentralized identifiers and blockchains, et cetera. Regular users can't understand how to protect these things or whatever. So the fiduciary responsibility for me is probably the most important thing out of this. Some real quick things. I think it's important you have series support here. I have an intellectual property series in Wyoming, because property rights are really confusing, and the best way to do it was just as fractional shares in a series LLC. So make sure you support that. Beware of certification standards having kind of lock-in. Standards change, and there's a history of standards organizations doing certification, locking in an industry. We really want to be clear on uses with all of this. So for instance, the heartbeat example was given, which I think is great for health purposes or whatever, but there's these unintended uses that become the problem. So part of what these protect are against either unintended uses or whatever. We give it to Google or Apple Watch or whatever, and they can use it for all kinds of things that aren't intended. And then finally, a note for Brendan, be careful with keys as identifiers. Keys need to be rotated. Don't use keys as an identifier, and contact me if you want to find out how to not use them that way. Thank you.
Thank you, Mr. Allen. Appreciate that. All right. All very good comments. We've got a lot for this working group to work on, and I look forward to that product, because this really is a great area for opportunity for Wyoming. All right. Committee, any further discussion or further questions or points for any of the folks that provided testimony? All right, seeing none, public comment is closed on that. Any further thoughts or desired action? I think we're just going to continue as we're going. Yes, we are. So thank you to that working group, and please continue into the next legislative session. All right, up next on the agenda is University of Wyoming updates. We'll hear what's been going on at the university. President Ed Seidel is joining us. We'll give him an opportunity to weigh in first. And then we've got Steve Lupian with the Blockchain Center for Excellence. And I believe, do we have Jim Caldwell here? I see Ruben Gamboa. Professor Gamboa is here. Bill Mai is here. I don't know if Professor Caldwell, there's Professor Caldwell coming in. All right, so we've got everybody here. That's great. Welcome, everyone. We appreciate having you on the Blockchain Select Committee. And President Seidel, the floor is yours, and welcome.
Thank you, Mr. Chairman. I'm really pleased to be in front of this committee. I'm slowly getting to know people across the state, but this is an area that I'm really, really passionate about. And perhaps, if it's all right, I'd like to just maybe give you a bit of an overview of a little bit about who I am, to the extent it's relevant for this, and kind of a vision for a broader digital strategy for the university and for the state. Would that be all right?
Yeah, absolutely. Please
Terrific.
proceed.
Well, so you know that I've been here since almost 6 months now. I guess that makes me almost a Wyomingite. I'm looking hard. We're working hard on becoming a real authentic person here, and I really enjoy it, and I love it here. When it comes to my background, that's relevant. I'll just throw a few things out there so you have a sense, like the way I think about things. I was most recently the Vice President for Economic Development for the University of Illinois, and developed a partnership across the whole state that was based in no small part on digital innovation. And my pedigree there includes a stint as the director of the National Center for Supercomputing Applications. I was at the National Science Foundation as an assistant director for a while, and I led all of the cyber infrastructure programs across NSF, including supercomputing and big data and such things, as well as mathematical and physical sciences, quantum information science activities, and those kind of things. When I kind of emerged from being for 4 years in the federal government and eventually came back to the University of Illinois, I also started up a thing called the Midwest Big Data Hub and the National Data Service as well. So, not to throw out too many acronyms, but it's just, this informs a lot the way I think about how these digital technologies are going to be driving the future of the economy. And so therefore, as the university president, I'm going to be very focused on trying to grow our digital footprint and then making sure it applies in a way that helped grow the economy. So that's just important for you to know, I think. Secondly, I'm on currently a national commission called the Council on Competitiveness that's actually having its first report out tomorrow after a couple of years of work. And this is a really heavy-hitting group that has presidents of universities like MIT and others, as well as CEOs of companies, Bank of America, and so on. And their strategy that will be rolled out tomorrow, at least the first version of it, will be a lot around how the United States generally has to be much better at innovating in order to keep up with what's going on internationally. And China is the biggest country that they're concerned about, and we're concerned about, I should say. But it's not only that, it's Germany, the UK, and so on. So we're falling behind in terms of our investments in innovation. And there will be recommendations, for example, that every state create an innovation council that's reporting to governors and other things like this. And so I think the main message is that we're kind of connected at the national level of thinking, and I want to bring this back to the state. And so there's still a lot of time for us to develop that going forward. So in terms of what the agenda that I would have for the university and for the state, of course, I'm still just getting warmed up here, but I have a pretty aggressive strategy developing that I'm beginning to work on with people in the legislature. I've talked with the Chairman Rothfuss a number of times about this. Also corporate partners, also the community colleges. I've worked very hard with getting to know the community college leadership, including yesterday. We had a Zoom session with all the presidents of all the community colleges to think about not just the university strategy, but really a broad statewide strategy around things like education and workforce development, and then also going the next step towards economic development, really supporting the growth of new companies that are going to be advantaged by technology. This doesn't just mean apps in computing, it means how these technologies, but particularly digital ones, impact every market from agriculture, livestock, mining, everything you can imagine. And when I was at Illinois, I met with the CEOs of a lot of major companies in every market sector. And the first thing they would ask me is, how can you help us with cybersecurity? How can you help us with artificial intelligence and applications and so on? And I'll tell you, and I don't mean this too negatively, but we're off the mark in terms of other states, in terms of, and the university, where we need to be, where we could be in terms of growing our digital footprint, in terms of education programs and so on. So I'll give you an example. We have a strong, feisty computer science department. Some of the representatives are here, but it's not critical mass. It's below, it's less than 10 professors. The university I just came from, in the same department, just the Department of Computer Science, hired 23 new faculty last year alone in that department. It gives you a sense of how fast these areas are growing. So we have to do better. And so I've been talking with, I've seen some of my colleagues here, Ruben and Jim, on growing a school of computing across the university, one that would not just be in engineering or in computer science or electrical engineering, but it'd be one that would be across the entire university, so we can integrate with other areas in agriculture and business and so on. And the Center for Blockchain is an example of an integrative center. I'll come back to that in a minute. So of course, this is in the sort of the visioning phase right now, but it would require funding, I think, from the private sector, from corporate partners, and of course from the state in order to do this well. But we would be very focused on education and workforce development and economic development. A second thing of this, part of this is other assets in the state, like for example, the NCAR Wyoming Supercomputing Center. And some of you know, I've seen this from every possible angle, including having recommended to the NSF. I chaired a committee back in 2007 that led to the creation of the NCAR Wyoming Center in Cheyenne, to being inside the NSF. So I know the program staff and know their vision for this. And now sort of having ended up here, and I see there's an asset there that we could take advantage of. And so we're talking a lot about with NCAR, the leadership, and with the NSF in the last weeks, even just the last couple of days, about how we can grow this. And I'm very, very interested in doing this by potentially getting funding from the federal government as well as from local consortium, potentially of other states. We've also had a conversation with universities across the entire rural Mountain West with the presidents of many universities about this, including just a few days ago, again, on this very topic. They're interested in working with us. Now, the Supercomputing Center is interesting in itself, but it could be used much more aggressively in a corporate partners program for economic development. The center that I ran at NCSA, the National Center for Supercomputing Applications, has a corporate partners program that brings in about, I don't want to exaggerate, it's at least $12 million a year in corporate partnerships of both local and national companies to help them understand how to take advantage of high-end computing, data science, artificial intelligence, and all of these kind of things. So NCAR Wyoming could become an anchor for that sort of thing. And I have a lot of ideas on how to grow that sort of thing. At the other end of the spectrum, when I talk to companies about moving here, and I was at the Jackson Tech Summit back in October, and I was at the Blockchain Stampede and the Wyoming Hackathon, which are amazing events. Really, really impressed with the organization and the impact that those activities are having. But you talk to the companies there about, well, why don't you move to Wyoming and work with us? And they ask, well, how much computing do you have at the university? How much workforce have you trained in this area? And so they're concerned about whether we have enough. So I've been working with the community colleges. We've already begun to talk about and are planning a software engineering program for all the community colleges to participate in, a 2-year software engineering program. And we're doing it in collaboration with our own Department of Computer Science and with external partners. For example, Cardiff University in Wales, which is actually very, very, I have strange historical connections to Wales, the Welsh government, and Cardiff University. They have a Welsh National Software Academy that has been operating for 2 years. And I happened to be at the opening of that 2 years ago. And it's in order to help diversify the economy of Wales, which is based on coal mining and sheep, which will sound very familiar to a lot of people here. And so we are having conversations with them on almost a daily basis now about how to adopt their 3-year software engineering program into a 2-year program for community colleges and potentially a 4-year program with the University of Wyoming. And we think we can do this within a year to get something like this rolling. So stay tuned for that. But that would vastly increase the talent, the trained talent. We have lots of talent here, but trained talent in this area that will make us more competitive. I'll just say a couple more things. Chris, I know I may be going long here, but I want to say a couple more things about this. We've also already, I've only been here for a few months really, but we have already launched a very exciting proposal to the National Science Foundation on artificial intelligence to be actually leading, not just participating in a proposal for AI at the national level. It would be a $20 million center for artificial intelligence and its applications specifically in things in Wyoming, but with a national team backing us, including Argonne National Lab, Oak Ridge National Lab, Brookhaven National Lab, and their associated universities, Illinois, University of Chicago, Northwestern, really top-notch universities across the country. They're backing us. So part of the strategy here is to bootstrap our way up to a nationally competitive level by having partnerships that help us get going and then investing as ourselves with corporate partnerships behind that as well. So maybe that's perhaps a bigger, just a hint of the kind of things that I'm thinking about, but I'll just say, maybe to get back to blockchain specifically, I'm very bullish on blockchain, not just the technology and not just the cryptocurrency side, but the fact that Wyoming really can become a leader, not just also in bringing in, say, the digital banks and those kind of things, but also the application to the supply chain around, for example, agriculture, business. I just had a conversation this morning with Central Wyoming College about sort of farm to storefront and farm to table and all the logistics, and how blockchain can be a really important part of making that side of the industry much more efficient. And so we're already talking about things like that. So the Center for Blockchain that the university has embarked on, and I'm a big supporter of it, is I think an important piece of this overall ecosystem that can have a lot of impact. I don't know, maybe that's enough. I could go on for another couple of hours, but I just wanted to give you an introduction to what I'm thinking about.
Thank you, President Seidel. Appreciate that. Any questions for President Seidel before we go on to others from the university? Well, President Seidel, we certainly appreciate the support, and this is exactly what we want to see. We want to see this organically grow. We want to enable university endeavors and partnerships and research, and we want to provide opportunities for funding that are consistent with the work that we're trying to do for business development. And if we can have both of those firing on all cylinders, I think things are going to go very well. Go ahead, Joel.
Thank you, Mr. Co-Chairman. Just a quick question. And recognizing you've been here only 6 months, but as you look at the state, the resources, the advantages, the structural advantages, are there economic growth opportunities that you see based on your experience, your knowledge of the technology sector, that Wyoming should be focused on? Private sector economic opportunities?
President Seidel, go ahead.
Yes, absolutely. Thanks for the question. So I think we're moving in the right kinds of directions. I think right now, one of the key things I think we need to do, in addition to laying out a vision for this, is to make sure that we have all hands on deck pointed in the same direction. We have a number of activities at, say, individual community colleges or at UW or in Cheyenne and so on. So we need to organize in a way that we can make a statement, a big statement to the rest of the country that is looking at Wyoming, by the way, to see if they should try to start up, have a presence here, or perhaps have an office, or even start new companies here and so on. They want to make sure we have the capacity to support their growth. So I think that's the foundational thing we have to do. Then there's specific markets, for example, around agriculture. I really think that the blockchain plus agriculture is a big thing that can be done. The banking area, we just had a conversation, I see Steve Lupian here and others, with a guy named Ray Brooks, who's talking about reinsurance. And also I know Chairman Rothfuss also was involved in that. So there are areas where I think we can get a bit of a head start on others, but if we don't move fast, we won't have a head start for long. But these are some areas. I think moving with NCAR Wyoming to try to grow that, and then getting our basic organization around some kind of a school of computing, so we can grow our footprint of computing, not just at UW, but in collaboration with the community colleges. I think it's a really important aspect. They're all excited about the idea. So these are just some initial elements that I can see where we could begin to have some real impact if we move quickly.
Thank you, President Seidel. Any follow-up, Joel?
No, thank you.
All right, then let's go to Majority Leader Dockstader.
Thank you, Mr. Chairman. President Seidel, as we get more of this rolled out and solid and on the ground, would you be opposed maybe to having some type of, even just a news conference with the co-chairs, maybe a half-day guest speaker thing once we're past COVID, something that really establishes that University of Wyoming is on the forefront of this all across the nation, all across the world for that matter?
President Seidel?
I think that would be fantastic. I'd love that. And by the way, Senator Dockstader, thanks for showing me around Star Valley some months ago. I was recently back in Alpine, and I just really enjoyed my time there. Just last 2 weekends ago, so I really enjoyed that.
Thank you, President Seidel. And I'll note, President Seidel, that we do have a presentation tomorrow from Mr. Brooks based on the reinsurance discussion that we had earlier. And I wanted to make sure after our discussion about that our select committee heard about it as soon as possible. So we've got that in the morning tomorrow. And again, great opportunity potential there. And I appreciate President Seidel for putting that together for us.
Thank you.
Any further questions for President Seidel? All right, seeing none, Director Lupian. And you are on mute. That's the mantra of 2020.
Yes, it is. Thank you. Thank you so much. I want to thank the committee for allowing me to speak and give you a little bit of an update of what's going on with the center. As you're all aware from the last meeting in October of this year, we created the Center for Blockchain and Digital Innovation at the University of Wyoming. And in the last couple of months since we've been stood up, we've done a couple of things. First of all, just getting the foundational docs in place, and probably the biggest focus right now is establishing our advisory board. Our advisory board is going to be interdisciplinary as the center is, and will include members of the faculty, 3 deans that have been supporting the center, and corporate partners. We've already received commitments from companies such as IBM, Golden State Foods, and some others to participate as advisory board members, and also to donate to the university as well. So our first advisory board meeting will be in January, and so I'll certainly advise everybody as to what takes place there. Our focus at the center to date has been, first of all, fulfilling our educational mission. And we are in the process right now of presenting the paperwork to create an undergraduate minor that we are planning to stand up the fall of next year. And we will have a business component to it, as well as an engineering and an ag component as well too. So it'll fit President Seidel's interdisciplinary vision for the university. We're also working on a online certificate program, and we are also in the process of planning for our next hackathon. As President Seidel had mentioned, our last hackathon was successful beyond our wildest imagination. We had over 4,300 participants in this last hackathon from 97 countries, well beyond what we had envisioned. I think the docket we had of speakers was probably one of the best blockchain speaker lists that I've seen of any conference, and we certainly will continue to do that moving forward. We're also engaged in a number of programs throughout the university that we believe will have economic impact on the state. One of them is we're working with the College of Ag to develop a sage grouse token as part of the legislation that was passed on sage grouse habitat. We're exploring and we'll be looking into a carbon capture credit, and hope to have some more information about that in the coming months. And as has been mentioned earlier, I've been in a couple of meetings to look into how we can domicile some reinsurance business here in Wyoming. And interestingly, there may be a little bit of a nexus with the Speedy Banks as well too, so we could get a double benefit to the state, not only in however the reinsurance business looks, but they're gonna more than likely need to utilize the Wyoming banking system as well too. And if we do some tokenization, then the Speedy Banks would certainly make a lot of sense there. The strategic plan for the center has really focused on 3 activities that we're doing. The first activity is just creating a greater awareness across the university and the community about blockchain and how it'll benefit the university and the state. So we're well underway in that, and frankly, creating the center, I think, was a very big part of starting that. But now we're continuing to do more outreach throughout the universities. And as President Seidel has mentioned, we've been reaching out to the community colleges. We've been reaching out to some of the high schools through K through in the K through 12 programs. I think you're all aware of the incredible stuff that's happening, for example, in Shoshone. And so we certainly want to facilitate some of that as well too. The next thing that we're going to be doing is essentially inventorying the capabilities of of the University of Wyoming in this space. There's actually a bit of bench strength at the university around this space. And so we want to make sure that, you know, we have a cohesive plan on how we're going to you know, provide education. Look, I believe the University of Wyoming can produce some of the best students in this space, certainly with the work you've done to create a enabling environment here. You know, Wyoming, you know, really is in the lead. Others recognize that. And so the university having strong programs to create the best students certainly makes sense. But we also have to make sure that we have faculty that can deliver on that educational promise. So we're you know, just starting to inventory what those assets within the university are. And then we're going to look to see, you know, where do we need to, you know, bring in external resources to fill those gaps until, you know, we can fill them ourselves within the university faculty. And then the last and I think very important thing we're doing as well too is economic development, because if we don't build a robust economy around this space, then to some extent, really, what's the point? You know, we don't want to, you know, create the best students just so that we can send them to Denver or Silicon Valley or New York. You know, certainly we need to have an economic environment here in Wyoming so that, you know, our chief export isn't our college educated youth. So that's kind of where we're spending our time. Last thing I wanted to mention is what we've been able to do on funding. Several years ago, the legislature, you know, very generously created a matching grant for the university for $1 million for blockchain education. $500,000 of that was generously donated by IOHK Global, and we used that to create the a blockchain applied lab that Dr. Caldwell will be speaking about, and that was matched by state funds. Since then, we've been able to receive private donations for another $500,000. So I'm happy to say that we have now completely utilized the matching grant that you've made available to us. So I want to thank you for that. And so that grant actually expires in at the end of this year. So we came in right under the gun, but we were able to bring in an additional $496,000, which is the balance not brought in by IOHK. So I want to thank you for all that. And I will tell you that we are continuing even beyond the matching grant to speak to organizations who want to work with the university. And soon, I think I'm going to be able to announce a few more partners that are joining us that will be you know, working with our advisory board, but also generously donating to the university. So with that, Mr. Chairman, I'm open for any questions.
Thank you, Director Lupien. An excellent presentation, and it's great to hear that much happening since the last time you came in and presented to us. It's clear that a lot of work has been done by a lot of very good people, and I'm also very happy to hear that the funds were matched. That's obviously important to us, and it's important if we want to go back to the legislature and seek more funds, particularly in revenue-constrained times, that we know we can get those matched and that it's a good investment. So thank you for the diligence on that. All right, committee, any questions for Director Lupien? All right, we'll stick around. We might have some. Thank you very much.
Thank you, Mr. Chairman. Thank you, committee.
Absolutely. Professor Caldwell, Professor Gamboa, welcome. I don't know which one of you wants to sort of lead the discussion, but you're both welcome to chime in, but please introduce yourself to the committee as part of the standard process.
Yeah. Hi, I'm Professor James Caldwell from computer science, and I think I know everyone here on the committee fairly well by now. I think maybe let me introduce, when we started this, I used to be the department head from computer science. And since then I've stepped down and Ruben Gamboa has taken over that position. So I don't know, Ruben, do you want to start off, and then I'll give a report on what's going on in the lab.
Sounds great. Ruben, welcome.
Thank you, Mr. Chairman. First of all, let me just thank you guys for inviting me to appear before this committee. I have prepared some very brief opening remarks, and I look forward mostly to answering any questions that you might have. I know we're time limited.
Great.
So as a computer scientist for the past, I find this hard to believe, but 40 years, I've witnessed many advances in technology. There's the explosiveness of the internet, mobile applications, cloud computing, mice, webcams, and of course, distributed meetings like this one. Some of these advances are revolutionary, and they require those of us in universities to adapt what we do and what we teach to the new world. At the Department of Computer Science, we believe that blockchain is one of those revolutionary advances. So we're strong supporters of this technology in a number of ways. For the past few years, we have been a part of the Wyoming Hackathon that was previously mentioned and the related conferences. Our faculty and students participated directly in these. Staff from the College of Engineering and Applied Science have helped to make it happen. So we are definite partners in that endeavor. You're going to hear more about this later, when Jim speaks, but our faculty is also involved in blockchain research and projects. We have a growing portfolio of courses in the blockchain space. It's also worth mentioning that blockchain builds upon many core concepts in computing. For example, cryptography, distributed computing, consensus. And the department continues to cover many of these topics in a more general setting. So even though a lot of the stuff that we do is blockchain specific, a lot of the other stuff that we do is blockchain supporting. And I think that's an important point that I don't want to lose. The department will also support the new blockchain minor from the Center for Blockchain and Digital Innovation. As part of this support, we will be teaching courses that will be required or approved electives for a minor. We'll also be publicizing and encouraging our students to pursue this minor. I think this is a great opportunity for them. Finally, we believe that there will be many other opportunities, perhaps facilitated by the center, for collaborations across the campus and beyond. And as a department, we really look forward to these collaborations. And you will mention different colleges and all sorts of things. Anyway, thank you for your time and continuing support. And I'll be happy to answer any questions as they come up.
Excellent. Thank you, Professor Gamboa. Any questions for Professor Gamboa? All right. And I'll ask a question that President Seidel was getting at a little while ago, which is kind of the critical mass and number of faculty. How many faculty do we have right now within the department?
We have basically 10 full-time, and we are down from previous years. We are hanging in there. I know that this is a very tough year for additional resources. We're hoping to be first in line as the new cycles come around.
And Professor Gamboa, how many computer science majors do we graduate?
Roughly speaking, graduate, I'm sorry. So we graduate about roughly 40 to 50 per year. Okay. I'm teaching the capstone course, and we have 45, I believe, right now. So that's kind of the body.
Okay, excellent. And getting back to sort of an aspiration point, pursuant to what President Seidel was talking about, I mean, what should we be graduating? Should we be up to 100? Should we have twice as many faculty? Is it more than that? As we're getting into this space and trying to develop it, if we do have some type of a college of computing, what should we be shooting for?
Well, I look at some of the other universities around us, and they're basically bursting at the seams, at least in the computer science departments. I mean, they cannot build enough resources for them, essentially, and they're hiring faculty at a rate not quite what Illinois saw, but not too far off. About half that. So we're seeing some explosive growth nearby. I don't fully understand why we're not participating in that. I think we should be. And another way of looking at that is we're producing all these graduates, say 50 a year. Are they getting jobs? The answer is yes. So I think the demand is there for our supply. If we increased our supply, I'm not at all afraid that they would not be able to compete. So I think we have quite a large upside if we could somehow execute in the recruiting and those kinds of things to be able to make it grow. I would feel comfortable at double. I've looked at other institutions that have kind of done that, and I talked to the department head of an institution in the Southeast, and he basically told me 5 years ago we were where you are right now, and today they have 600 students in the major and a very large cybersecurity contingent, and they're just going gangbusters. So I could see us do some of that.
Thank you, Professor. And the other question I had was right along those lines, and President Seidel mentioned the critical mass concept. I know one of the keys to developing a research program is not to just have one professor that's doing a particular type of research, but to have a body of professors in each area, and whether that's cryptography, cybersecurity, blockchain. What do we have as sort of priority programs on the horizon? What do you see as being those key programs? Blockchain's obviously one of them, but what else are we working on? And how many faculty do we need to sort of fill that out so that we have an appropriate number? And if we lose one faculty member, you don't lose a concentration area.
Heaven forbid we lose a faculty member right now. But in the last central position management, I specifically applied. This was my highest priority. Was somebody in kind of secure distributed computing, which is an umbrella term that includes blockchain, but also has a little bit more flexibility. And that I still see as the highest priority for our department. We have a good group that is working on cybersecurity. It is subject to the rogue bus that tramples a poor computer science professor, and that would kill an entire discipline. So we do want to beef that up very much. And it dovetails very nicely with what this committee is looking at. So that was a priority for me. I probably continue with that, right? We do have some other things that we do quite well, like artificial intelligence, machine learning. We could definitely use help there. And we have faculty members that are working, for example, with CU Boulder, doing a three-dimensional augmented reality, mixed reality type systems. That's also an area that I see growing. And if we succeed, and it's not an if, when we succeed in the software engineering path that we've undertaken, we'll definitely need some help to fill in some of the roles there that are adjacent to computer science. So there's like 4 or 5 people there, and I realize that's gigantic, but as long as we're dreaming.
Excellent. Thank you, Professor. Any other questions yet? Go ahead, Representative Yen.
Mr. Chairman, thank you. Now, I don't really have a question, more of a comment. I just wanted to thank all 3 of you and for the pursuit of all 4 of you for the pursuit of not just the blockchain space, but creating computer science, a computer science space in the university, as well as creating a workforce of future software developers or future computer scientists. As someone with a computer science background, I definitely know and am aware of one leg of economic development. If you want to have businesses move to Wyoming, one of the things that you need to create that stool for businesses to sit on is workforce, right? And I think the university is going to be a big part of that going down the road, and I for sure want to support you guys. So I look forward to seeing more of the workforce that you guys pump out, as well as more of the big events that you guys bring people from all over the world with. So thank you.
Excellent. Thank you, Representative Yin. Any further questions for Professor Gamboa? All right, thank you. And Professor Caldwell, anything else to add? Tell us about the lab and tell us about any other thoughts you have to follow on, Professor Gamboa.
I guess I would just first like to thank President Seidel for being the first upper administrator we've had at UW who really sees that computer science and the technology that's come in, software technology, has touched the entire planet, really. In the past, we haven't really seen that kind of awareness that not just does it touch the entire planet, but it touches every discipline at the university as well. And so I'm really pleased and welcome President Seidel to the university with your exciting plans for growing the space and software and computers. So just I guess maybe a quick update on the lab. If you like, we could, we give monthly reports to IOHK on our progress. We could share those with the committee if you're interested in sort of seeing a month by month account of what's specifically going on in the lab. But the bigger picture is that we have 4 research projects underway right now with, I should first say, with 3 professors, including myself. And one of those is Mike Brofchek, who is pretty heavily loaded at the university level and also with the cybersecurity lab, but the joint work between his Cedar lab and WABL, which is the Wyoming Advanced Blockchain Lab, is, a perfect fit and a good and really a nice synergy between the 2 groups. In the IOHK lab, we have 2 PhD students and 2 master's students, although one of those just graduated. Took a job with an AI startup, I believe, in Laramie. So that's good news. We have 4 research projects going on. One is we're implementing a Cardano node, which is, kind of similar to becoming Bitcoin miners, but for IOHK's blockchain Cardano. So we have a pretty advanced, we're ready to go on bringing the node live after a number of months of constructing the software and doing the security analysis of it. And that's in team with the foundation, which is going to put in some ADA to stake the node as the initial stake for the node. And then there are classes in Department of Finance that we've already had some interaction with, giving lectures about how the blockchain works and so forth. So they're very interested. So that's the node work. We have work going on with extending IOHK's smart contract programming language called Marlowe, which we're pretty excited about. We have kind of perhaps our main objective from IOHK was for us to design and develop an RFID chip for authentication of ownership and provenance. We're working on that. We're, thanks to Steve's participation, looks like we're going to be hiring a very, very prominent cryptographer to help us do to analyze the protocol that we've put there. And we also have and this is kind of at the intersection of the Cedar Lab and at WABL, is the side channel, cybersecurity against side channel attacks. So, that's when you don't necessarily hack into the computer, but you're able to do things, especially with like an RFID card. You don't want people to be able to, put the card in a scanner and somehow figure out how to break the purpose of the card. So we're getting started on that. We've also had one of the things that Steve referenced was that there is, a slightly deeper bench maybe at UW than we realized. I mean, since our lab started, we started a series of seminar talks, and we've had somebody from philosophy who's published in CoinDesk and in philosophical journals on the philosophy of cryptocurrency, which is rather interesting. And we're kind of looking forward to working together with him some. We had him give a kind of a meet and greet talk. And we've also met with someone from petroleum engineering who is working on a a kind of a market, you know, a token-based market for carbon credits and looking at that side. And so, you know, we've got people kind of coming out of the woodwork once they hear, oh, there is this new lab on campus, and hey, what are you guys doing? Are you in? Here's what I'm doing. And so we've reached out and fully are, you know, thrilled to have these outside people come in and talk about their projects. I think our main thing is we've been set back by COVID in terms of recruiting more undergraduate students into the lab. You know, our goal was to have a dozen of them working in the lab, but really it's just kind of, you know, basically been impossible to figure out how to do that through all this online mechanism. So as soon as we start meeting again in person, we'll be able to grow the undergraduate research component of the lab, which we think is really important for grooming students to come up into the graduate program. Oftentimes that's a source of our best graduate program. Our students is our best undergraduates. So, you know, we're excited about the grouse credit program with Steve's group is looking at, and we've been on some of those meetings. So we're looking at all these things, but we need more, you know, we need more people, really, more worker bees. We can't, you know, I between myself and Mike, and we have one full-time Philip Schlump, who is a full-time professor of practice with our group, but he teaches 2 or 3 courses a semester. But and he's the one that sort of took on the protocol for the chip. So in any case, we're, you know, we can certainly use more help. There's lots of projects to be done. And I have to say this grouse one is especially exciting because I think that could turn out to be a public-private partnership that's extremely, you know, focused on Wyoming issues. But, you know, there are 11 other states, I think, in the Rocky Mountain West where sage grouse are an issue, and this, you know, it could be and it could be a relatively large market. There could be income coming from running a market like that. And I think once you have one like that, it's relatively easy to adapt it and make it work for cheatgrass. Or there are other kinds of eco credits out there that the state is very interested in, that Wyoming could become a leader for the Rocky Mountain West in terms of how do you manage these kinds of programs. So I guess I'm open to questions.
Excellent. Thank you, Professor Caldwell. Appreciate that. And President Seidel, I know that it's my understanding you've got another meeting coming up, so I wanted to give you an opportunity to have any final thoughts before you have to run, and then I'll get back to questions for Professor Caldwell.
Well, thanks, Mr. Chairman. So I'm actually waiting for a phone call. So if it doesn't come, I'll just stay with you for a while. But
perfect.
I'll just say I'm excited by this. And I want to maybe add one more point about the sort of scale of things, maybe a couple of other comparisons. Some people have said when I've compared us to Illinois that, well, we're not Illinois, but let's compare. So we look up to Illinois, but Boise State should look up to us. And they're already twice our size in computer science, and they have a doubling plan already in place. And just as an example, we're gonna grow, and we're gonna find ways to do it. So, thanks.
Excellent. Thank you, President. All right, questions for Professor Caldwell. Well, Professor Caldwell, you know, each of those programs I think is exceptional. I was part of the subcommittee that put together the legislation on the sage grouse. And honestly, as we were doing it in our little subcommittee meetings, I was talking about the possibility of tokenizing it and trying to contemplate legislation that would allow it to be tokenized. Honestly, it's not perfect for it. I would have liked a few changes, but it turned out the Game and Fish didn't like my ideas as well as I did from a tokenization standpoint. But I'm really glad to hear that is a project that's underway. I think that's exciting. And yeah, conservation credits are a very big potential marketplace, as we know, for tokens. And if we can start developing in that space, I've seen some really interesting applications, so I'm enthused about that application. We appreciate it, and I also know that, you know, when you get the more worker bees on the ground, there's more opportunities to get research funding, to build partnerships with industry, and that helps us to cultivate the environment where you can get more faculty and have the resources to do it. So we'll do our best to provide that support as well by helping to build those partnerships with you. Additional questions? Any other additional questions, topics, or discussion for the university at this time, committee? All right, seeing none, thank you all very much.
Okay,
this is all
great.
exciting, and we look forward to the next update in a few months. We'll make sure that we have an opportunity to have you come back and visit with us again.
Thank you, all of you, for your support.
Take care, everyone. Select committee, 5-minute
Thanks for your
break.
support.
So back at about 3:12, 3:13, somewhere in there. Mute and mute your video too. See you all in a minute.
Now we don't have any audio whatsoever.
stuff that. On mute on us.
All right, select committee, if you're out there, come on back and join. Almost quorum. Division of Banking. All right, we've got a quorum. Let's get back rolling again. Hopefully the rest will join soon. Next item on the agenda is updates from the Division of Banking, and we'll also be considering some amendments that are proposed as well. So we've got a few updates, and with that, I'd like to welcome Commissioner Faulkner and Mr. Land. The floor is yours, and feel free to guide us through the discussion points as you like.
Okay, thank you, Mr. Chairman and committee members. Albert Faulkner, Banking Commissioner. And with me is, as the chairman said, the legendary Chris Land.
Oh gosh, please don't say that on the record. Yeah.
It's there, it's out there. Thanks, for giving us some time. Whenever you say an update from a regulatory agency, I assume you've blocked off the next 4 hours for that, because you might
Probably more like 12 minutes.
Okay, that's better. Make sure and always put rails around us, otherwise I'll bloviate. No, there's been a lot going on. And actually, I'll just give you a quick highlight of an update, but then we'll kind of get to the proposed legislation. So, as the committee members are well aware, Wyoming continues to make its mark on the country as well as the rest of the world, and we continue to engage with folks from around the world. It would involve digital asset activity, and then on the regulatory front, so we're working on trying to put in place some operating agreements, information sharing agreements with other regulators, such places as Bermuda, such Abu Dhabi, and then we'll be looking at some other countries as well that some of our chartered entities also have a footprint. So we want to be able to work collaboratively with them. We want to be able to make sure if any activities in those jurisdictions were to harm or potentially harm the Wyoming charter, we know about it and can take the necessary steps, but also just to collaborate on innovative ideas, innovative regulation, and things of that nature. So making some good strides there. I think we may have mentioned that we're also working on finalizing a supervisory manual and examination handbook and procedures for the new special purpose depository institution bank charters. Again, that's a first of its kind in this country. Other regulatory agencies are trying to get their hands on it. We're trying to hold on to it because it was expensive, at least for a while. So we're trying to figure out if we can get a bidding war going. But anyway, no, it's we've definitely tackled a number of issues consistent with what the legislative body's done and trying to tackle the issues legislatively and provide clarity. We did the same thing over the supervisory manual. It's comprehensive. It's built on a common foundation of existing supervisory procedures. Because if you think about it, the bank at its core is still a bank. But we definitely tackled some. Promontory Financial Group was our contractor, and just a tremendous company to work with, a massive amount of knowledge that was provided to us. So that we're getting ready to put the finishing touches on that, and we'll have that in place, if not by the end of the year, early in January. That kind of completes the process for us. I've got my staff in training, the bank examination staff this week with our blockchain transaction monitoring firm that we contracted with, Chainalysis, to learn basically the fundamentals of crypto, but as also the tool itself. And if anyone's familiar with Chainalysis and their product, and there's others out there, CipherTrace, Elliptic, things like that, they're very powerful tools to be able to help us ensure that the institutions are doing their proper due diligence, BSA, AML compliance, know your customer. That area continues to develop rapidly as well with the federal agencies. So we were the first state agency to contract with Chainalysis, so that was pretty exciting. They're excited to work with us, and it's, like I said, it's going to be a great tool for us to make sure that that they're not using the Wyoming charters for nefarious purposes. So those are, that, like I mentioned before, we've had our legislative, our regulatory, and our supervisory process. So I'm pretty proud of the work that's gone on in 2020 amidst all the chaos that is out there. And sometimes chaos in here trying to get all these things done at once, but
Usually
nevertheless,
chaos.
yeah, I've learned that's the new norm. So much for being just a country bank regulator. So anyway,
I'll throw in a couple things.
yeah. So that's part of it, and I will let Chris give a few pieces of information as well.
Yeah, Mr. Chairman, members, kind of give you an update on where the SPDI chartering is and our trust company charters as well.
Perfect.
Yeah.
Yep, please do.
So we have two SPDIs that are all the way through the process. Their applications are currently pending with the Federal Reserve System at the moment and have been since around November 1st. Working with the Federal Reserve on a very, very consistent basis. Have had a lot of engagement, and there are a lot of folks in a lot of places in the country in the Federal Reserve System that are working on these applications right now. Maybe a point where it might be interesting for the select committee to make their views on the SPDI charter known to certain folks. We'll be in touch on that possibly. But yep, that process continues. And then on the other two SPDIs, we'll be accepting in the very, very near future 2 further SPDI applications, and with the banking board hearings likely to be held in March of April of next year. And they have, each of the 4 SPDI applicants has very divergent business models, so it'll be a good group, I think, in the end. On the trust company space, we have 5 or 6. Okay, we have 5 trust company applications at the moment, and I don't think there's ever been a point in Wyoming's history where the Division of Banking has had 7 bank and trust company applications at the same time. That's basically 2021 for the division. We actually have an application from a company that's interested in having a trust company for digital assets. So that'll be the first one of those, in addition to, you know, 2Ocean, which is, you know, one of our existing trust companies that's doing activities in the crypto space. Since we last met too, you know, the division adopted the no action letter on digital assets that, you know, prompted the SEC to respond on several issues. It was generally seen in the industry as, you know, being positive and moving the ball forward. And yep, that's basically all I have to share with you at this point, other than noting that Representative Lindholm, I think this is the first select committee meeting that I've seen that Representative Lindholm wasn't on. So I guess he's was he on earlier, Mr. Chairman?
He was. I don't know where he went. Representative Lindholm, are you trolling? No. Maybe.
Mhm.
We'll just pretend he's nearby, but yes.
Yeah.
And that was, I guess, if there's any questions for us.
All right.
before we dive in.
Questions on the update. Obviously, there's more work ahead from the Division of Banking, but questions on any of the topics that have been raised so far, the trusts, the speedy banks, anything else? Go ahead, Ms. Long.
Mr. Chairman, question for Commissioner Faulkner and Mr. Land. With all the activity relating to companies in the digital asset industry applying for national bank charters, what does that mean for Wyoming's special purpose bank charter? What are the differences? And is the OCC one of the agencies that called you for your supervisory manual?
Yeah,
Mr. Land or Commissioner?
Mr. Chairman, thank you, Ms. Long. Yeah, absolutely. For those people that follow this, the Office of the Comptroller of the Currency and Brian Brooks, who's the acting comptroller, at least for about 30 more days or less than, he actually has a background from Coinbase, and so it's not unreasonable to expect that he would have an interest in pushing this at a national level. Yeah, and part of it is, it really, they'll never probably admit it, but the comptroller's office is very much, I think, envious of what we've done here. And there's some benefits of being a small state, and with a nimble and active legislature, we were able to get things done, as we all know, they're on this here, much quicker than a federal agency can. There's pros and cons. They've got a national footprint. A lot of our things just impact the four corners of the state. But yeah, so as the leader of the organization, he's definitely thrown down the gauntlet about what he would like to get done in his short tenure. The supervisory team is trying to keep up. So yeah, they have been very anxious to see if they could take a look at or get their hands on our manual. It's not complete, so that's buying me some time, but so it's interesting, the resources that they have, and they're looking to us to look to see what we've developed. We've answered a lot of questions that really haven't been answered at the national level. And it's one thing to go out and advertise what you would like to do. It's all, as we all know, it's much different to get it done. And so while he's been, and the OCC's been aggressive,
Very aggressive.
you know, yeah, it's to some extent a little bit of it to the detriment of Wyoming, because it's clouding and it's making things a much cloudier, disjointed conversation in DC, and we're kind of getting caught up in that a little bit here, because people are trying to figure out, you know, are we doing something crazy that the OCC would, you know, is trying to do as well, and if they can't do it, why should we be able to do it, or vice versa? You know, those are areas that are outside my expertise of how the inner workings of things on the Hill work and between the federal agencies. I will say, if I had to guess, there's a lot of, there will be a lot of over-promising and under-delivering at the end of the day. Like I said, January 20th is not that far away, and there are definitely a few financial agency heads that will be told that their services are no longer needed, probably minutes after the inauguration, for the political aspects of it. So that may very well, a lot of people are thinking that he will probably be one of those. What does that mean going forward? I don't know. It's anyone's guess. It really depends upon who sits in the comptroller's office. But like I said, just to get things done at the federal level is just such a slog. But he has a much bigger megaphone than we do here in Wyoming. When the comptroller speaks, It is like EF Hutton, people do listen. When I speak, I'm not sure even my staff listens half the time, but nevertheless, I think we're still in a good place. We're still seen as a leader in the country, and we've talked to, I briefed the committee before, we've talked to at least 10 other states that are really looking closely at what we're doing here and to see if they can do something similar.
Thank you, Commissioner. Anything to add, Mr. Lamb?
Nope.
Okay, well, when you send that handbook, make sure you find an old mimeograph, get him a paper copy, and do it by budget ground.
Yeah.
All right, any further questions? Ms. Long, any follow-up? Okay, thanks. All right, Commissioner, please proceed. Next agenda item, if I can find my agenda, which is buried here somewhere. There it is.
Yeah. So yeah, Mr. Chairman, that and what I'll do is I'll just kind of tee it up, and then I'll turn it over to Mr. Land, who's been living all of this and living down in these weeds for quite a while now. But as would be expected, building this, and really as quickly as the state of Wyoming has built the legislative framework, there's going to be probably regular refinements. And so what this proposal is again, just refining the existing law to provide continued clarity, more clarity. And a lot of this, and I'll let Chris delve into it more about some of the questions that we receive from prominent law firms around the country that have clients that are interested in Wyoming. They raise questions or say, have you thought about this? Or, we're not quite sure what that means. And so we continue to tweak that. And so Chris has put together this proposal, and let him kind of walk you through that, if that's okay, Mr. Chairman.
Absolutely. Chris, go ahead. And so hopefully we're all on the same page with 21 also 335 working draft 0.3 that you're going to be discussing with us, the needs with regard to digital asset amendments. Okay, excellent. Please proceed, Mr. Land.
Thank you, Mr. Chairman. So this bill is, very technical. There is one or two substantive pieces that I'll explain in greater detail. But what this bill largely is a product of is more conversations with law firms, trying to make it more consistent with, the traditional Uniform Commercial Code approach to assets, and giving more clarity and a space to make Wyoming's laws more effective and the SPDI more effective. As you can imagine, these laws have, been the subject of several articles and lots of scholarly discussion, lots of practitioner discussion, and these are largely the sum total of those comments. So I'll just start on page 2. So the change on page 2 is non-substantive. When the word includes is present on line 13, it suggests by implication that there could be other assets that would be a digital asset, when that wasn't the legislature's intent. It was the legislature's intent that it either be virtual currency, digital securities, or a digital consumer asset.
Okay.
Page 3 is the first change on line 6 and 7. That is a substantive change, and I'll explain why. What's the point of designating these statutes a consumer protection statute? Mainly because under UCC 9201, the Uniform Commercial Code, section 9201, which is the citation there on line 7, this gives Wyoming a stronger argument as far as choice of law and our UCC framework applying versus another UCC framework in another state. There is an exception in 9201 that says a consumer protection statute has precedence as far as choice of law in certain areas. And I'm comfortable making the choice of our law argument here if the legislature agrees, of course, because there's so many unknown liens on digital assets in this space, and uncertain legal regimes, and uncertain whether it would be able to enforce a contract. I think there's an easy consumer protection argument to be made that the agreement that you make with your custodian or your bank should be enforced, and that promotes stability and predictability in the market. So what this provision essentially does is it takes advantage of existing language in the UCC that says a consumer protection statute, it gets more deference as far as which law applies. Okay, the second change on page 3 is non-substantive. It just makes it more readable. There isn't an actual change here. It just breaks up the language to say possession applies to virtual currency and control applies to digital securities, which is also consistent with the UCC.
Mr. Land, on that point,
yeah,
consistent with Wyoming statute was removed, but I'll just pause there and get your thoughts on that.
Yeah. So before it was implying that you should reference 3429.102, and and then decide which asset you had. So if you had a security, then you would automatically, by implication, go to UCC Article 8 because you have a security, or virtual currency is money under Article 9. So the statute was achieving by implication what we're now achieving by direct command in the statute, which was confusing some practitioners. So
understood. Thanks, Representative Greer. Was that a hand up, or you just happened to be going near your camera?
I'm sorry, Mr. Chairman. I'm on my iPad here, and so every time I touch something, I have to reach up. Sorry.
Understood. No worries. Thanks.
Okay. So the changes on page 4 in the first block of text on lines 1 through 7. The change on line 2 is another technical change, which is unnecessary based on the language that was added on the previous page. And then the other changes on lines 3 through 7 are comments that were suggested by a law professor to make it more technically sound with the Uniform Commercial Code. So this, it's bringing us more in line with the UCC. There are a lot of exceptions, and this applies, but this doesn't apply. That's mainly because there were hijinks previously with the existing UCC language, and this just unties those knots. Okay, the change on line 4. The change on lines 11 through 12 on page 4. This came from a prominent Wall Street law firm that pointed out that sometimes you'll have multiple parties to a security agreement. It's not just you need to, in more complex transactions, you have to accommodate for that. So that's what that change is.
Sounds good.
Okay. Page 5. Page 5 and the bottom of page 4, because the staff comment applies to page 5 on C on page 5. So this change, all the changes on lines 1 through 6 are mainly to specify that the existing UCC, we're not changing the rules for perfection by filing under the UCC. That's the reason. If a debtor is located in Wyoming, that's the only reason why you would perfect by filing under the UCC is if the debtor is located in Wyoming. One article seemed to suggest that was an ambiguity. This is one professor's opinion. Couldn't hurt, but this isn't among the most essential changes in this piece of legislation. So I'll move on. Page 5, lines 8 through 15. That change. The legislation previously failed to specify when the 2-year lien cleansing provision would apply. It said actual notice, but it didn't specify when you didn't have to have notice. And this just says now that if you have actual notice at any time during the 2-year period, you're not able to access this provision. If this language isn't added, it'll be up to a court to decide probably, where they come down. Okay, the changes on lines 20 and 21 is just adding a signpost for practitioners to existing in the UCC. Page 6, lines 2 through 4 is again adding another signpost to the UCC, and also strengthening why Wyoming has made the argument that possession should apply to virtual currency. We've classified virtual currency as money for the purposes of UCC Article 9. And one of the kind of the hallmark tenets of possession under commercial law is the ability to exclude others. So when a judge is interpreting the statute, I want them to think about that fundamental concept that possession is the ability to exclude others. Because what Wyoming did was, previously, possession only applied to tangible objects under the UCC, and that's one of the steps that Wyoming has taken in classifying virtual currency as money under Article 9. Is we're saying that because of the bearer nature of virtual currency, and by bearer nature, I mean if you don't have your private key, you don't have the ability to transact in virtual currency, right? So in some ways, it's a bearer instrument. Bearer instruments fall more appropriately under the possession category than control, because control means that you could have multiple parties exercising some, influence over an asset. But possession means, if I have this cell phone and I'm holding on to it, no one else can do anything with the cell phone, physically, right? Virtual currency is kind of the same way, because it has a possessory nature that you can exclude from others. So we're just adding that signpost to make judges realize that, yeah, there's an analog to possession here, and hopefully strengthening the case that a judge would apply Wyoming law as written.
Chris,
Okay, yeah.
Sorry, on that point, when you start talking about exclusion, excluding others, and we're talking about multi-signature arrangements, I'm contemplate like a 3 of 5 signature, or something along those lines. Does any individual then have possession of it? Because any individual is unnecessary and cannot exclude 3 others from accessing a digital asset.
Yeah. So the language actually isn't included in the bill. It's existing statutory language that isn't being touched, but it actually says a multi-signature arrangement for it to qualify under possession, it has to be exclusive to the secured party. So think about it. A company, let's say a bank who took a security interest in virtual currency, that bank, they could have a 3 of 5 arrangement within the bank, and they would still have exclusive possession, mainly because they all have the same interests, right? They're all working for the bank. The bank's the secured party. But the moment you step outside the bank, there wouldn't be that possession anymore, because their interests are diverging. So you can still have a multi-signature arrangement, but it would be under different conditions. You and I couldn't be in a part of a multi-signature arrangement for Albert's Bitcoin and still have the requisite possession. But we wanted to facilitate the use of multi-sig within legal entities, for example, because it's a best practice for security.
Okay, understood. Thank you.
Thank you, Mr. Chairman. Okay, the changes on the bottom of page, page 6, line 14, otherwise held, doesn't really have any meaning because it's either going to be possessed or controlled, so the language doesn't need to exist. That's all that change does. And then page 6, lines 20 through 23. This just clarifies the language based on what some attorneys in the space have requested to make it more clear. Page 7, lines 4 through 8, or sorry, lines 4 through 6. This is another suggestion that was suggested by a Wall Street practitioner who's in the secure transaction space. He pointed out that you can have multiple choices of law in a contract. You can say that Section 1 is governed by Wyoming law, Section 2 is governed by Delaware law, and Section 3 is governed by New York law. So that's just recognized. It's very complicated, but it's recognizing that for the more advanced practitioners, they want to take the pieces of the very best laws and apply it to their transaction. And then the changes on the bottom of page 7, line 17, this just recognizes again that you could have either possession or control as applicable to the asset. Same change is made on page 8, lines 15 to 16. And then the changes on 19 and 20 merely say that there will likely be other terms as part of a lending or a transaction agreement with a digital asset and, other customary terms that are present in securities and commodities transactions today. And then the staff comment on the top of page 8, we're going to accomplish. We've already accomplished that by rule, so I don't feel the legislature needs to. But it's not a deal. It's not a massive deal one way or another if the legislature were to just incorporate those definitions by reference. But I would mention that possession, helpfully, the words possession and control have different meanings under securities law and commodities law and the UCC. For example, the Commodity Futures Trading Commission recognizes that you can have possession and control of virtual currency, whereas that's completely out in left field for the UCC. So these words all have different meanings in different bodies of law. So I don't think it's the best idea to extend those definitions to custody. But it's something we can fix by rule if necessary. But thank you, Mr. Chairman.
Thank you, Mr. Land. On that last point, so it sounds like you would prefer that we not apply to 28, 34, 29, 104D above because you want the
interpretive flexibility.
Yeah. Okay. All right. Thank you. Anything else, Mr. Land, before I go to questions? Not right now?
Nope.
All right. Questions, committee. I saw Ms. Long.
Yes, Mr. Chairman, a question for Mr. Land. We just literally today had a conversation, and actually last night had a conversation about another area of the statute that users have found a little bit confusing. And so this relates to, it's not in the bill draft because it wasn't being amended, but it relates to the it's what would continue at the bottom of page 7 in 3429-104D, where there are 2 different relationships for each digital asset held in custody. We were allowing in D(1) either a bailment or either a fungible bailment or non-fungible bailment. And then in D(2), we allowed a bailment of what is effectively a UCC Article 8 security entitlement. And that was confusing to users. So at the appropriate time, Mr. Chairman, I would like to propose a further amendment here to this bill to add some language, well, actually to strike some language that would help to clarify that. I wonder if Mr. Land would like to share at this point, since we're right there in this bill, whether that is something you'd prefer to do or not do.
Thank you, Ms. Long. Mr. Land.
Thank you, Mr. Chairman. Ms. Long, I definitely agree that's another potential change the committee should consider. It's literally just striking 3 words in 3429-104D2, under a bailment, unquote. It's duplicative at a minimum and confusing at worst. So.
All right. Well, let's make sure we get that amendment raised and proposed. Thank you. Any further questions for Mr. Land at this time? All right. Seeing none, thank you, Mr. Land and Commissioner. Let's head to public comment now. I think unless anybody on the committee has anything they want to say before we go to public comment. All right. Seeing none, let's head to public comment. Mr. Meyer, I see you. Please introduce yourself to the committee and to the public, and the floor is yours.
Thank you, Mr. Chairman. Scott Meyer, President and CEO of the Wyoming Bankers Association. We've looked at those changes that are proposed by the Division of Banking and have no objection.
Excellent. Nice, short, sweet, and concise. Thank you, Mr. Meyer. Any questions for Mr. Meyer? And Mr. Meyer, any thoughts on the while you're here, this little proposed amendment that was just discussed between Ms. Long and Mr. Land? Any concerns with that structure?
Mr. Chairman, no concern.
Thank you. Any other questions? All right, seeing none. Mary Beth, do we have any other testimony? This was all I think I have.
Mr. Chairman, you have Christopher L., and I believe he wants to provide public comment on this.
Okay, great. Thank you, Mary Beth. Mr. Allen, it's been a couple of minutes, so brief introduction, and then the floor is yours.
Yes, my name is Christopher Allen. I'm with Blockchain Commons. I'm a blockchain technology expert and have been an advisor to this community for a couple of years. I really wanted to, ask for some clarity on some of the multi-sig scenarios. So first off, I wanted to appreciate that this distinction of possession and control is important. I'm not quite seeing all the edges of it in the various multi-sig scenarios. So maybe Chris Land might be able to speak to. So let's take a basic, 2 of 2 wallet or 2 of 3 wallet where you've temporarily given somebody the ability to help protect your assets by making it such that you can't, you can't spend funds without their permission for a brief period of time. There's a number of parties, Green Address, I think Unchained Capital and others that use this type of thing. And the interpretation has been that, these parties who facilitate, since they can't spend your money without you, they don't have control and thus, aren't subject to custody things. But they do stop you from spending, at least during the term of the time lock, which can be, a couple of months to a year or so. So is there anything in this new discussion about the applicability of time locks and the ultimate, the reality is with these types of scenarios, neither can spend on until the time lock is over. And I know that these companies, Unchained Capital and others, would be concerned that they would be considered to be custodians when in fact they can't spend the money ever without total, cooperation from the other party because their time lock expires. It's the ultimate possessor's time lock that expires. So that was my question for Chris and the larger discussion and multi-sigs. Thanks.
Yeah, thank you, Mr. Allen. I appreciate that. And Mr. Land, let's consider Mr. Allen's question. What are your thoughts?
Thank you, Mr. Chairman. A couple of things I want to point out. They wouldn't be considered a custodian because they're not a financial institution. I'm not sure what that particular company's legal status is, but to be a legal custodian under securities or commodities laws, you have to be a regulated financial institution generally or have some kind of license. The next piece is there is some interpretive flexibility that's built into 3429-103. Currently, it reads use of a multi-signature arrangement exclusive to the secured party or any substantially similar analog. That substantially similar analog gives courts and our office the ability to consider, analogs that are substantially similar, and it's built in to provide that flexibility for time lock arrangements. Additionally, I'm not, the UCC would only generally be implicated if there was, the legal requisites for a secured transaction. You don't always need a security agreement to have a secured transaction, but it's generally indicative of having a debtor-creditor relationship with some kind of security agreement. So, to the extent that there isn't a security agreement present, that's another indicator that that they would not have control or possession under the Uniform Commercial Code.
Thank you, Mr. Allen. Appreciate that clarification. And Mr. Allen, we certainly can't go through all of the scenarios today, but it does seem like maybe just running through a series of different multi-sig scenarios and use cases, and then applying the language and checking out whether possession is appropriate might be a useful exercise if we can get somebody to run through that. And Mr. Allen just popped back in, and I'd ask him to run through that scenario and maybe team up with somebody to scenario test those concepts.
Yeah, we've been experimenting with very complex things, including 4 of 9, which is actually 2 of 3s, in a quorum of 2 of 3. So yeah, there actually are reasons why some of these things are more secure. So I will look through them. And
thank you, Mr. Allen. Appreciate that. Okay. Any other public testimony at this time?
Mr. Chairman, I don't have anyone else on my list.
All right, great. Chris or Commissioner, Mr. Land, excuse me, or Commissioner, any final points before we close public testimony?
Mr. Chairman, if with the committee's indulgence, I'll say a few words. I wish Representative Lindholm was here as well, but I want to thank the committee for their leadership in this area the last couple of years. Our great working relationship and all the hard work that a number of legislators and our office and LSO and community stakeholders have made, because it's made Wyoming's blockchain ecosystem one of the most advanced and envied in the world, and it's certainly been mostly because of the folks on this committee and certain others in the legislature, Speaker Harshman, President Perkins, and the Governor Meade and Governor Gordon. Really just want to thank you for the opportunity to work with you, and things are going to be changing here shortly. I'm going to be doing the same kind of work, but in a different format. Hopefully, still making a difference for Wyoming, just in more helping to safeguard and enhance what the legislature's done. And I really appreciate the opportunity. Thank you.
Thank you, Mr. Land. And on behalf of the Select Committee and the task force before, and all the folks that have been working on this over the years, we just wouldn't be here without your work. There's no question about it. And your diligence, your hard work, the many ridiculous hours that I remember you putting in drafting all of these bills and then redrafting them and then trying to get them right and seeking additional input. It's the reason why it's clean. It's the reason why it works. It's the reason why we've been successful. And really, you were critical, and we wouldn't even have the Select Committee today at this point in time were it not for your hard work. So believe me, we know we're still working with you. You're just going somewhere else. Yep. So it's not the end of the conversation, and we look forward to doing great things in the future. But really, thank you for everything that you've done, both with LSO and the Division of Banking, and in your future role as well. We look forward to it. And with that, I'm going to recognize Representative Lindholm.
Yeah, thank you, Mr. Chairman. Mr. Land, I'm glad that you've been stolen away from the Division of Banking finally after he rudely stole you from me.
You're breaking up, Representative. You didn't come through clearly. I'm sorry,
right. But no, I did want to mention, Mr. Chairman, that and I tell this story to people because I think it's important to note just about who we're talking about when it comes to Chris Land. So I want to make sure that folks know it, that are watching in on YouTube, all over the world right now. The fact of the matter is when we first started down this path, I called up LSO, called the main secretary line, said, hey, I need an LSO attorney that knows something about technology. And they said, well, we got this new guy that just started for us. I said, well, yeah, let's talk to him. So Chris picks up the phone and he says, this is Chris Land. I said, Chris Land, welcome to LSO. I got a project for you. What do you know about Bitcoin or blockchain? Nothing, Representative. I said, perfect. Can you start studying on it? He said, I will. And at this point, I think we're at just 3 years later, Chris Land has written more legal precedents in regards to blockchain technology and digital assets than any attorney in the world, because of the tremendous amount of hours that he put in. I mean, the amount of time that this guy put in. I mean, Wyoming owes you big time, Chris. So it's you're a legend, buddy, and I'm excited. I'm excited where you're headed. I'm excited to see and read about what you're going to be doing, and it's going to be good.
Mr. Chairman, am I entitled to some rebuttal time about Representative Lindholm there?
Rebuttal granted.
Yeah, thank you, Mr. Chairman. No, I just want to say that echo Representative Lindholm's sentiments kind of the other way, and kind of, shine the mirror back on him, mainly because, so much legislation, it remains in the land of theory and abstractness. And, it takes the hard work of, the political stakeholders and, both houses to actually translate it from, a theory into actual practice. So, my hard work is, probably not as important as the actual execution, because I just had to make all the pieces fit together, legally speaking. So, this committee, Representative Lindholm, Senator Rothfuss, Representative Greer, Representative Yen, Vice President Driscoll, Senator Nethercott, and the other members of the legislature, that's mainly because of you guys. So it really was a pleasure working with you. And as Tyler said, he's not going to have to read about what I'm doing. He's going to be in the same same place I am. So I think everyone knows kind of what's going on. But you can read about it in the Casper Star Tribune. But anyways, I just want to thank the committee again, and like I said, stay tuned. We're gonna try to build upon all the great work Wyoming's done so far. Thank you.
Thank you, Mr. Landon. I hope I can still send you drafting requests. Is that okay still? I don't know.
I'm actually going to be, I will be doing a bit of drafting probably in DC. Okay. It's different drafting though. So.
Okay. Well, we'll see.
Yeah.
Thank you so much.
Mr. Chairman, I would note too that Congress has finally passed an air ambulance fix. So look for that's going to be effective very shortly. It's in the omnibus bill, so keep a lookout for that.
I know nothing about that, so call me later. Thank you.
I will.
Yeah, it wasn't just blockchain that Mr. Land wrote some pretty damn good legislation about. So that's exciting. Thank you.
Speaker Barlow is going to be particularly excited too. I probably should give him a call.
Yep. All right, excellent. All right, back to the committee. We've got a couple more updates that we'll get to in a second, but let's take a look at this bill and work the bill. Is there a motion on the bill?
Move the bill.
We've got a motion. Second. I see a second from Senator Nethercott. Let's run through it. Any amendments on page 1? Amendments on page 2? Amendments on page 3? Amendments on page 4, amendments on page 5, amendments on page 6, amendments on page 7.
Yes.
Ms. Long.
Mr. Chairman, I would propose to amend, and for LSO's benefit, we will be amending 3429-104D2 to strike 3 words under a bailment. So that now reads custody pursuant to subsection E of this section, instead of custody under a bailment pursuant to subsection E of this section.
Thank you, Ms. Long. We've got a motion. I see a second from Senator Nethercott. Is that clear, Mr. Hopkinson?
Yes, Mr. Chairman.
Thank you. Any discussion on the motion? Seeing none, all those in favor of the motion to amend, please raise your hand. Any opposed? That motion is passed unanimously. Any further amendments on page 7? Any amendments on page 8? Seeing none, is there any discussion on 21 LSO 335 working draft 0.3? Digital assets amendments? Seeing no discussion, roll call, please.
Mr. Chairman, this is a roll call vote on 21 LSO 335 version 3 as amended. Senator Dockstetter.
Aye.
Senator Driscoll.
Aye. Sorry about the slow on the mute.
Senator Nethercott.
Aye.
Representative Greer.
Aye.
Representative Lindholm.
Aye.
Representative Yin.
Aye.
Co-Chairman Olson.
Excused, we'll catch him in a moment.
Co-Chairman Rothfuss.
Aye. And let's hold that open and get Co-Chairman Olson back over here. And while we're on that topic, we have now Representative Greer here to cast his vote regarding 21 LSO 216 version 0.5 digital identity. He did listen to the debate, but wasn't able to weigh in at that time. So Representative Greer, would you like to cast your vote?
I would. Thank you, Mr. Chairman. I apologize. I've got a weird work schedule going on right now. I had to step away. I did hear the debate, and I'm a no vote on that bill.
Great. Thank you, Representative Greer. And that vote should be closed now, Mary Beth. And I think we had a passing majority on that, if I'm not mistaken.
We did, Mr. Chairman, and I would note that it was version 6.
Oh, my apologies. It was version 6. Okay. Thank you. All right. And Representative Lindholm, go ahead.
Yeah, thank you, Mr. Chairman. I'd just like to note that I am super thankful that I don't have to present that last bill, that I won't have to present these types of bills anymore, because they're all damn hard work. And so good luck. Good luck, committee. That's that digital digital asset amendments. That's
Yeah, I was contemplating the same thing, Representative, and I was hoping for the House's sake that Representative Yen was taking very diligent notes on all the explanations that Mr. Land just gave.
So Mr. Chairman?
Yep, go ahead, Representative Greer.
Yeah, well, Representative Lindholm, it got a lot easier because I'm not debating against you with these, on all of them anyway.
That's not lost on any of us, Representative Greer.
Yeah, Mr. Chairman, it is important to note that Representative Greer is here for a very, very specific purpose. It's so that he quit messing with us on the floor. It's 0 good times.
You're all the testimony. Excellent. Thank you. All right. Very good. With that, briefly, just a quick update, Representative Lindholm and Ms. Long on KYC AML discussion.
Mr. Chairman.
Oh, here we go. Hold on. One moment. Co-Chairman Olson.
Mr. Chairman?
We did just vote. We held it open for you. Would you like to cast a vote on 21 LSO 335 digital assets amendments as
I was
amended?
tracking amendments, and then after Ms. Long's, I got sidetracked in my other meeting, so I may have lost an amendment after that.
No, it was just Ms. Long's.
Okay, then I can vote?
You can vote.
Okay, I vote aye.
Excellent. Thank you, Mr. Co-Chairman.
Thank
All right,
you.
Mary Beth, that should close out the vote.
Yes, it does, Mr. Chairman. Thank you.
Great. All right, so we passed that one as well, and that'll probably be if we end up with a short session and having priority legislation. I think we'll try and get that digital assets amendments on the books as quickly as possible, because it affects too many things not to. So we'll have to figure out what the heck it does. All right, excellent. Anyway, back to KYC AML. Ms. Long and Representative Lindholm, any thoughts on what's been going on there with the working group?
Do you want me
Mr.
to kick
Chairman?
the ball?
Oh,
Go ahead, Ms. Long.
Ms. Long.
Yes, Mr. Chairman, just real quickly. I wish I had a better report. In fact, actually what's happening is that there is a lot going on in Washington, D.C. So the work, I think, frankly, to help solve some of these issues is going to carry on by our 2 friends who are moving on to work with Senator Lummis on this very issue. She has actually already gotten involved in it as well. And the challenge is that the philosophy at the federal level is, and it literally just came into, there was another piece of evidence of it yesterday. The philosophy is that no one should have privacy in their financial assets. The example I was pointing to yesterday pertains to what is in effect a preemption of Wyoming's LLC privacy procedures, where we don't collect beneficial owner information, and the commercial registered agents can they by law have to know who the beneficial owner is, but only if they're subpoenaed do they have to give that information up. Well, now it turns out that the beneficial owners of corporations have to be disclosed, and frankly, all the banks are going to have all that information. So in the KYC arena, what's happening is it's being expanded even more. Now the so-called travel rule is going down to $250, which effectively means that financial institutions have to know the identity and report potentially suspicious transactions all the way down to $250, which effectively for all intents and purposes is every transaction. And so all financial institutions are doing this. The compliance burden on financial institutions related to this is really stunning. And yes, of course, it has a lot to do with digital assets, because by nature they can be more private, because they can be bearer instruments, but it's a bigger issue for the entire banking industry. And what remains to be seen is whether the pendulum is going to swing in the opposite direction under the Biden administration. But what is happening on the way out the door is that Secretary Mnuchin is actually proposing some pretty onerous restrictions. Rumors have been flying all over the place about what those restrictions are going to be. And I'm very grateful that Senator Lummis has also gotten involved in that, that essentially would make it illegal for anyone to have a financial asset that's not publicly disclosed unless it's physical cash. So it would have a huge impact on what's in the digital asset industry. It would have a huge impact on what's called an unhosted wallet, basically for you to take your digital asset outside of an intermediary, because then the government doesn't necessarily know who you are and how much money you have. And so it's a pretty onerous restriction. But again, the broader point is that this is a bigger issue for than just for the digital asset industry. It applies to the whole banking industry. I think you'd be floored if you understood just how much information the government is collecting through our financial institutions about all of us, and Congress is going in the opposite direction. Unfortunately, there's not a whole lot, it would appear, that we can do at the state level, but I'll turn it over to the working group co-chair, Representative Lindholm, who may have a more optimistic conclusion about this.
Oh, you're muted, Mr. Chairman.
Thank you, Ms. Long. Representative Lindholm?
Yeah, thank you, Mr. Chairman. Yeah, Ms. Long is spot on. And honestly, Mr. Chairman, I do have a lot of confidence in the state legislature in finding a solution. Unfortunately, we haven't found the hole yet. Now, that's not like a negative aspect, right? Sometimes these things take a little while. What we did with meat just a couple of years, or just this last spring, took six years to find that hole. And I suspect that there is a hole. And I suspect that out of anybody, the state of Wyoming legislature will find that hole on the BSA that needs to be taken advantage of. But like Ms. Long said, there is traction being made in regards to the BSA and how that's currently being handled. And I do know that there's priorities on the Hill with several ranking members in regards to what the BSA should look like moving forward. Even the bigger banks were complaining about the BSA during the PPP program. They couldn't get loans out fast enough because they could not conduct know your customer regulations. And so if it's affecting the big banks who have a wealth of amount of money to be able to handle those regulations, that's affecting negatively our small community banks. And there is a priority for everybody to get this deal fixed. Whether or not Congress can get it done is another deal. When it comes down to Secretary Mnuchin's recent moves on saying he was going to move forward with some regulation, I do think that he will do that. I don't think it'll be welcomed by too many people, though. It effectively amounts to know your customer's customer, which is crazy. And it would only apply to digital assets. So it's a regulatory, definitely a regulatory hurdle because of that is being done in emergency powers, essentially, emergency rulemaking. It'll come up to the next Secretary of the Treasury to handle that. And as all of you know, that will be former Federal Reserve Chairman Janet Yellen. And Ms. Yellen's statements in regards to digital assets have not been negative or contrary. They haven't really been pro either. As far as we all know, she's fairly neutral in that regard. So it'll be interesting to find out where she's at on it. I'm also very bullish in regards to our next senator, as far as her stand in regards to digital assets. She's been a fan herself for a number of years, but is also a #1 fan of the state of Wyoming. And so she's seen what this group has done and what the Wyoming legislature has done. and wants to help prop us up and make life easier for us here in the state of Wyoming. So she's moving forward with that. In light of her recent hires, I think it's fair to say that she's moving forward with that agenda.
Thank you, Representative Lindholm. And I think this committee, I'd entertain a motion to send a committee of two of our Wyoming best to Washington, D.C. and to really focus on this issue until it's fixed. If everyone's agreeable, I'll just take that as unanimous consent.
Mr. Chairman, can we only send one though? Because,
all right, we'll send one full time and the other one will just,
every once in a while.
Every once in a while go,
Yeah.
but still get it done. All right, that'll do. That'll have to do. All right, thank you for that update. Any questions for Ms. Long or Representative Lindholm on KYC AML? Excellent. I do think that the KYC AML work fits well with the data trust work. If we can get those pieces put together, then that would be a real win. All right, excellent. All right, that's it for the Division of Banking topic. We are now on to disclosure of private cryptographic keys. We worked this bill pretty heavily at the last committee meeting and had a good bit of discussion on it. This is the same bill draft minus the staff comment. I'll invite Mr. Hopkinson to join us here in case there's any questions about the drafting, but I wanted to hold off on the vote last time. Senator Nethercott wasn't here. I believe Senator Nethercott had an opportunity to kind of reflect on some of the testimony and understand some of the discussion, but I wanted to make sure that we had an opportunity as the full group with Senator Nethercott to discuss any remaining concerns with 21 LSO 0028 version 0.6 at this time. And we do have public testimony available, and we'll probably try and get to that, but it will hopefully be fairly quick and to the point. So looking at the legislation, as you can see, it is the same concise bill draft that we had last time, minus the staff comment. And the key difference from earlier drafts is the language that you see on lines 3 and 4 and 5 of page 2, which basically says that, or overall in context, says that a private key cannot be compelled unless a public key is unavailable or unable to disclose the requisite information with respect to the digital asset, etc. So in other words, if public keys are capable of getting the information needed, the public keys will be sufficient and no private key will be compelled. If the public key does not provide sufficient information, then a private key could be compelled. It's my expectation that under all circumstances hopefully would allow that only public key data would be provided and the private key could be protected, but would not exclude that possibility. And I think this was a good compromise that LSO worked to put together and get us hopefully where we need to be. So I'll pause there, see if there's any questions about the language, then we'll quickly take some public comment on it, and then we'll get back to the committee. So any questions on the language, and do we need Mr. Hopkinson to go over anything? Senator Nethercott, go ahead.
I thought that we removed, Mr. Chairman, the language concerning the criminal portion.
Senator Nethercott, I asked that be put back in. That was earlier, but with this, without criminal language there, it implies that it would be fine for criminal language because it's not in the list. And I was a little concerned about that. But once again, the exception circumstance where you can't get what you need from public keys seems like it would apply just as well to criminal cases. And we did have testimony at the last meeting where Miss Mary Beth was, who had prosecuted previously. I asked her if she was comfortable from her prior prosecutorial role with this language. as a U.S. attorney, and she felt comfortable with that from a prosecutorial standpoint. So I was hopeful we'd threaded the needle on this one. Senator Nethercott, thoughts? We can get to public testimony and get back to you too. Do that. All right. Excellent. Any other questions on the bill draft, on how it works or what it does? Committee, seeing none. Let's go to public testimony then. It looks like we've got two folks here. One of them tentative. We'll see. And we've got Mr. Allen. And Mr. Allen, we're trying to catch back up on time a little bit. We've been heavily through this. So quick comments on it, please.
Yes. So, Mr. Chairman, committee, and in particular, Senator Nethercott, I really appreciate your time in the last 2 years since this was first brought forward. To me, this is the heart of so many other discussions that we have here: security of blockchain, security of digital identity, the kinds of problems that around ability to make personal decisions that Representative Lindholm is an example of. All of this at its heart can only be secured in the virtual world by private keys. So that's why it needs this special protection, and why I really feel like any other answer risks so much. So I'm thank you for considering it, and I'm really hoping that it will be unanimous to move this forward, and that this will be a pivotal law for all the rest of the community. Thank you.
Thank you, Mr. Allen. And just to correct myself, a minute ago, I mentioned, because this is what's in the agenda, that this was 21 LSO 28 version 0.6. But just for those listening and those on the committee, the working draft we have before us for consideration is actually 0.7 because of the removal of the staff comment. But my understanding is nothing else changed from 0.6. So my apologies for that. And Senator Nethercott, did you have a question for Mr. Allen?
No, Mr. Chairman, but just a comment to the committee and any of those with public comment here forth. I appreciate the effort over the years to convince me it has been robust. I am unconvinced. But I will say this: I will remain a no vote because nothing is above the law or beyond the reach of the law, and I will remain committed to that. But I promise I won't try to kill it. And that's all I'll give. So take comfort in that.
Thank you, Senator Nethercott.
But providing accurate information is always on the table, but I will not try to kill it.
Thank you.
Thank you, Senator Nethercott. All right, thank you, Mr. Allen. Any further questions for Mr. Allen? All right, seeing none. Mary Beth, do we have any additional comments? Let's see, who did I have on my list?
Mr. Chairman, we did have a Brian Bishop, but he was tentative. And he is not in the waiting room.
Okay. All right, sounds good. And I see Ms. Long giving a thumbs up for that. All right, excellent. So to my knowledge, that concludes our public comment on the legislation. And with that, do we have a motion on the bill? We've got a motion from Ms. Long. Is there a second? See a second from Representative Lindholm. All right. Any amendments on the bill? Any amendments on page 1? Any amendments on page 2? Any amendments on page, probably not 3? Seeing no amendments, discussion on the bill. Representative Lindholm, go ahead.
Yeah, thank you, Mr. Chairman. My only discussion would be, as far as passage of said bill and what that looks like to the body, right? In the Wyoming House, it was introduced last time with just civil, and there was, even then, people were still talking about criminal, even though it didn't take into consideration criminal, the prior version. And it failed introduction, I think it was, by 1 vote. Now, granted, that's an introduction vote, so it was at 39. probably would have passed during a general session. I just want to bring up that aspect because I suspect that you're going to receive stiffer resistance with the criminal portion in there. Well, I certainly agree with the criminal portion and acknowledge that Senator Nethercott, as often happens, is wrong. But I did want to note that well, it certainly might be right to have criminal in there. It might make more sense to take a piece of the pie and just take the civil.
Thank you, Mr. Chairman. Mr. Kaufman.
Yeah,
Excuse me, Mr. Lindholm. Go
Thank
ahead.
you, Mr. Chairman. I'm going to echo that comment. You know, for what it's worth, over the past few months, I've sort of workshopped this with some clients of mine that care about this bill. None of them seem to care very much about the criminal language. And so my personal thought is, if we think that jeopardizes the bill at all, I'd rather remove it myself. I don't have strong feelings about it one way or the other, but my gut tells me that it's easy to strike it and maybe cleaner. So for what that's worth.
Thank you, Mr. Kaufman. Yep. Senator Nethercott, go ahead.
Thank you, Mr. Chairman. Mr. Kaufman, you ran it by your clients. Did you run it by any Wyoming lawyers or judges?
Mr. Kaufman.
Mr. Chairman, no judges. Yes, Wyoming lawyers, but admittedly all within my firm.
Well, what did they say?
Mr. Kaufman.
This is not admissible testimony, Mr. Chairman. This is hearsay. Yeah, I think everyone's in agreement that for a civil proceeding, protection of those private keys is pretty paramount. I mean, it's a fundamental underpinning of the digital asset space to make sure that those keys are protected, safe. You know, particularly with the space, I see Joel just got back on, but with a growing industry space where you would have third-party custodians of your private key, the idea that they could be compelled in some scenario to produce a private key because of some legal proceeding they're involved in, right, that might put your key at jeopardy, I think that's a big problem. And that was a major theme from a lot of folks that we discussed it with.
Thank you, Mr. Kaufman. Additional discussion. Any other thoughts? Well, I'll share my thoughts on the criminal aspect, and there's a couple things there. First of all, the bill last year honestly just wasn't as good as this bill in terms of its wording, because it didn't have the public key clarity and the exception language, which I'm hopeful will provide a great deal of confidence to folks that might have had concerns of the previous bill draft, where you have an opportunity to make a request for the private key and to compel that request for the private key if the public keys are insufficient. So you can do it. And what that means is, under a circumstance where the public keys are sufficient, let's be clear on this, that means the public keys are sufficient, right? That's tautological. You can conclude that you have all of the information you need from the public keys to make that a true statement, so that you can't ask for or compel the private key. If a judge decides, no, we don't have all of the information, regardless of whether it's criminal or civil or elsewhere, then that judge would say, I don't have the information from the public keys, therefore I'm going to compel the private key. So it's hard to say a circumstance where that's going to fail the need of the court. And that's what I would like to hear. If somebody has a concern where, oh, that doesn't meet X scenario, then we probably still need to work on it. But it is tautologically certain that either it's enough information for the court or they have a right to ask for more information by compelling the private key. And again, it's different from before. And then the second point with the criminal, we've got a couple of thoughts on that. The first is, if you leave out criminal, that basically says through omission that it's fine to ask for a private key if it's a criminal case. And remember, criminal cases are not just big, scary, awful cases. Criminal cases are little, tiny misdemeanor cases also. And I would hate to be the state that was known as the one that allows a judge to compel private keys under misdemeanor circumstances or little tiny felonies or things that don't matter very much, or something, you shoot 3 elk in one day, for example, which
Justice.
I'm pretty sure we made that a felony, Senator. And then the final point is, again, and this just gets back to a theme with the legislature, but we always seem to hate criminals, and we don't want to give criminals a break, even if they haven't been convicted. We're always willing to treat them differently. And this is the part where they haven't been guilty yet, necessarily even. So it's a circumstance where we're willing to lower the bar for the more important part of the justice system, which is the criminal justice system. And to say for that one, we'll lower the threshold. So to me, honestly, that's more important. And I realize that most of the folks that we talk to are worried about the financial side of things and who gets what money when. But at the end of the day, when we're putting together good legislation and we're protecting something, we should be protecting that across the board. And we should be very sensitive to protecting the privacy rights of those that are alleged criminals. And I still feel, even in the criminal circumstances, that it gives the court all of the discretion they need if they can't produce what they need that's appropriate from the public key. So I feel like we should go for the clean, the sort of purist draft, recognizing that my dear friend Senator Nethercott doesn't like it either way. But I do appreciate that she likes it better, and I'm confident that she likes it better. So those are my thoughts, and I'd be open to hear more thoughts. I saw Representative Yin's hand go up, and then I'll go to Representative Lindholm. So Representative Yin.
Thank you, Mr. Chairman. Yeah, I think I would agree with you that I do believe this is a better bill just overall. What I would say is that with regards to moving it through the House, I think I would assume that this bill would go through the Judiciary Committee. And I hear that the chairman of the new Judiciary Committee is a pretty good whipper of votes. So I expect that we could do it. If it does seem like that there would be a possibility of it hitting resistance, then we could always change it in Judiciary Committee. I don't think that would be an issue.
There are 2 chairmen of the Judiciary Committee.
But I suspect only one will be whipping votes for this bill. But I'm more than happy to move it forward in a clean version as we see in front of us.
Thank you, Representative. I thought the Senator Nethercott, the Senate chairman, was going to floor sponsor this, but that might not be happening. Well, Representative Lindholm.
Yeah, thank you, Mr. Chairman. I'm just going to give you my experience. I mean, I completely agree with you, Mr. Chairman, and Representative Yin in regards to your statements. You are factually correct. As you know, that is often not what pushes people in the Wyoming legislature. Facts don't matter sometimes. In fact, I'd say most of the time, it more matters how people feel about things. And in this regard, that sentiment will be pretty tough. And so I just urge caution in this regard. It's better to have a piece of pie than no piece of pie. So with that, Mr. Chairman, I'll make a motion to amend out, and this will be something that LSO will have to work through on the bill, to amend out anything to do with criminal from the bill.
We've got a motion, and that would be on page 1, line 13, strike criminal comma. And I believe I heard Senator Driscoll seconding that. Is that accurate, Senator Driscoll?
Yes.
Okay, we've got a motion and a second. Is there discussion on it? Representative Lindholm.
Thank you, Mr. Chairman. And I'm going to vote for the bill no matter which way this goes. And I just want to reiterate, Mr. Chairman, I do agree with you that criminals should be in there. However, I also would like to see this bill passed into law. And I think you've got a heck of a lot better chance with just the civil portion being in there.
Thank you, Representative. Senator Nethercutt.
Just a quick piece of information to share with the committee. They might find it a bit humorous. With the changing of the Chancery Court to our district court judges, I had Mr. Land do a presentation with them to kind of apprise them of all of the wonderful work that we have done. And so we did that last week. And it was really the district court judge's first time to really have any kind of true understanding of what we have done here. And I was, of course, very proud of Mr. Land and the work we've done. And and at the end of it, you know, one of them said, "We can't be doing this. You know, this is a haven for criminals. This is terrible." You know, and I, of course, didn't say anything, but I wanted to say, this is the law. And if this isn't a choice, this isn't, you don't get to vote on this or decide on this. This is the law. But that is where our current Chancery Court is. So again, I have not run this bill by them. They don't know, and I'm not going to. But I just want the body to know that that's where our Chancery Court is right now with the status of things, without taking any kind of control or power away from them regarding their ability to have any kind of judicial jurisdiction over these kind of assets.
Thank you, Senator Nethercutt. Additional discussion on the amendment?
Question.
All right.
Wait a second, Mr. Chairman,
Yes, there you go. Representative Greer.
would you please restate the amendment for me? I apologize.
Oh, no worries. Absolutely. The amendment is on page, my apologies also. There we go. It's on page 1, line 13, strike the word criminal, comma. So it would only apply to effectively non-criminal proceedings.
Okay.
Further discussion? All right. All those in favor of the motion by Representative Lindholm, put your hand up by the screen. 3, 4, 5, 6, 7. 7 ayes. All those opposed, hand to the screen. 1, 2, 3. That motion is carried by a vote of 7-3. So criminal has been struck. All right. Any further discussion on the bill?
Sorry, Mr. Chairman.
Understood. All right. Further discussion on the bill? Yep. Senator Doxter, go ahead.
Agree. I appreciate the note that one judiciary chair could work it through the system, but I'll respect the reservations of my judiciary chair as we go into this. So I'll be opposing it.
Thank you, Senator Doxter. Further discussion? Representative Lindholm.
Thank you, Mr. Chairman. As a note, I've heard that corporations chairman in the Senate might be friendly towards this type of legislation. Ideas, thoughts, throwing them out there.
Thank you, Representative Lindholm. I somehow suspect it's going to go to the Judiciary Committee. Representative Greer.
Yeah, Mr. Chairman, I'm going to vote aye on this to maybe get it out of committee. I don't know, but I'm going to reserve the right to nitpick it as we work it through the system. Okay.
Thank you, Representative Greer. Any further discussion? Any further discussion? All right. Well, I'll note that I'm going to be a no vote. I do feel that it actually erodes more than it helps once you explicitly eliminate criminal from the list. It makes it a strong point that criminal is no longer protected and that a private key could be compelled. And so I think by clarifying that through omission in statute, we actually decrease what is currently an uncertain position where I don't believe there is any legal certainty as to whether or not you could or could not compel a private key. I think that without that, we actually do more damage and we would discourage people from coming to the state of Wyoming if they felt that we were eroding those laws. So I too shall be a no vote with my good friend, Senator Nethercutt. Additional discussion? Representative Lindholm, go ahead.
Yeah, thank you, Mr. Chairman. I would urge caution on voting no on this, on the aspect of erosion. The reality is when it comes down to this situation, we have heard from the largest law firm in the state of Wyoming currently representing these types of entities has said that every one of their clients is excited about that civil protection. Now, granted, that's not official testimony, that's hearsay. But so there is merit in this regard. There is a great deal amount of merit in this regard. And just like with a lot of the great pieces of legislation that this committee has done over time, we didn't get everything in the first sweep, and we had to go back and pick up pieces along the way. And so that's why I'm voting for this bill. Is I have full faith that this committee, once this piece is through the legislature, you can go back and pick up the rest. The only intent for my amendment was to make the bill more passable, and then we could come back and revisit and pick up more of the pieces along the way. So that would be my urge of caution to the committee, that there is still a great deal amount of merit in this bill, and don't throw out the baby with the bathwater.
Thank you, Representative Lindholm. All right. Any further discussion? Ms. Long, go ahead.
Yes, Mr. Chairman, thank you. Yes, I would encourage you to rethink your opposition to it. I understand and am very sympathetic to it. It would be much better if we actually did have an outright protection for this. This gets back to the encryption wars in this country. But honestly, 3 yards in a cloud of dust, and you win the football game. So if we can advance the ball, I feel like it's worth going, even if it's not perfect. So I would encourage you to support it. Although I would also welcome reopening the debate over whether we should have the criminal protection or not as well. This is with the problem with online with private keys, is it really truly does, if a judge can compel you in any circumstance, whether it's criminal or civil, then the judge can literally peer into your private thoughts. And we don't do that outside of the digital world. So we don't compel testimony outside of the digital world in the criminal courts. And I think, yeah, I would certainly have supported getting keeping criminal in, but I understand why that it may have a much bigger challenge in the legislature. So I'm all for taking the territory. Thank you.
Thank you, Ms. Long. Further discussion? Committee, further discussion before we vote? All right, seeing none, I see. Welcome back, Chairman Olson. You're here. With that, let's have a roll call vote on 21 LSO 28, working draft 7.7.
Senator Dockstetter.
No.
Senator Driscoll.
Aye.
Senator Nethercott.
No.
Representative Greer.
Aye.
Representative Lindholm.
Aye.
Representative Yin.
Aye.
Co-Chairman Olson.
I was very reluctant. I didn't get to participate in the debate. I think that Representative Lindholm's amendment was not probably well thought through, but there's a legislative process, so we can fix that.
Co-Chairman Rothfuss.
No.
Mr. Chairman, that bill passes as amended.
Thank you, Mary Beth. 21 LSO 28 0.7 has passed as amended. All right. We are on to wherever my agenda is. We are on to SIM card swaps. And honestly, you never would have guessed it, but we're really not that far behind. Does the committee need a 5-minute break? I think it's probably not a bad idea to do a quick fiver. Okay, 5 minutes. Let's come back at 4:46 and we'll start back up. Please mute your video and mute your sound. See you all in a
Mike, my oldest daughter passed up a hell of a good opportunity. She just about got her hands on a bunch of Angus crossed with Maine and some that were crossed with semi. 10 head,
Yeah.
10 head of show show cows, show heifers.
Yeah.
Yeah.
Yes. So that's my son. He's running 50 head of registered Simmentals, black Simmentals, and so we take those, using them for seed stock, and then we cross those with Vermilion Black Angus bulls, and it's we'll see. We'll be a few years out from a good look at it, but looks like it's working pretty well. So
they're good looking calves. They really are. That semi-cross is sure nice.
Yeah, Tiffany's done a good job with her herd. She got about 400 mother cows, and so they've been crossed with Simmentals up until about 3 years ago when they switched over to those Vermilion bulls. But the Simmentals are a little stouter. We calve in March, and they jump up off the ground pretty good. So good genetics there, good looking cows. And
got long little hair on them too. They make good. They make good show calves. For those listening in, show cattle are no longer about just putting fat on a critter. You got to put hair on a critter.
Well, most importantly is they taste good.
That's right. They do taste delicious. Anybody can pour grain on a critter though. God, my kid's got like 20 different hair products for their show calves.
Wow.
Or just hair products. Just hair products.
So that's like 5 or 6 more than you have for your hair?
I only got one. I got that natural.
Dapper Dan?
Dapper Dan.
Dapper Dan.
He's Dapper Dan.
I'm a dapper kind of guy. Everybody knows it.
I said my piece.
I'm a huge Coen Brothers fan. Yeah.
Chairman Olson.
I think I like this new format where I'm gone from the meeting and I just get to drop in the middle of a vote, cast a vote, say something about Representative Lindholm, and then leave.
You want to take that opportunity once again?
What was that? I'm going to vote for it, but I hate you, Tyler. What was that?
It was something like that. Absolutely. All right. Do we have quorum? 2, 4, 6, 7, 8. It looks like we do. All right. Let's get back started again. So, final topic for our agenda this evening is SIM card swaps. We had a working group comprised of Ms. Long, Representative Lindholm, Representative Yen, and Senator Nethercott taking a look at the legislation that we previously discussed regarding SIM card identity protection. We have that draft available to us today. And let's get a report then from the working group and what their determination was, what they found, what they discussed. And let's see, I think Representative Yin, were you lead on that? All right, Representative Yin, you can go ahead and start. The floor is yours and defer as you see fit.
Thank you, Mr. Chairman. I think I will actually defer this probably to Ms. Long, if that's appropriate. We did meet, we talked about it. We ended up deciding on the draft that we have from the last time before the meeting, and I'll leave it to Ms. Long to discuss why that is.
Excellent. All right. Thank you so much. Ms. Long.
Yes, thank you, Mr. Chairman. Yes, we did have a couple of gatherings to determine what to do. And the main question was, should we do anything? Knowing full well that the telco companies are going to come full force against this. And the challenge that we decided to, that where we landed is, yes, we want to make a stand against this. We're about to hear from someone who, contrary to the argument that this was all in the past and this has all been taken care of, who was SIM swapped on Saturday. So this is absolutely very much real, and it very much ties to identity theft. And we were willing to go forward as a group. I think we were unanimous as our subgroup that we did need to take a stand here. There's only so much a state can do. We would prefer to have this done at the federal level, but there is an identity theft angle here that is is a consumer protection issue, and we decided to go forward with it and keep the bill as drafted.
Thank you, Ms. Long, and look forward to that public testimony with identity theft. I'll just note that right now my wife has applied for 5 new bank accounts and I don't know how many new credit cards. She has applied for Wyoming unemployment. She's doing a lot of things that she's not aware of right now. And if anyone out there stole her identity, please send me a note. I'd appreciate it. Thank you. It's a real challenge to work through. There is no good process in place. I wish there was something we could do about it, but at least trying to prevent it would be handy. Representative Lindholm, did you steal my wife's identity, Representative Lindholm?
No, Mr. Chairman, I don't even know how to use a computer.
I know.
We keep talking about this Bitcoin or something like that. Bitcomm, I don't know. Mr. Chairman, I just want to throw my notes on the meeting that we had.
Yeah, go ahead.
Representative Yan and Senator Nethercott and Ms. Long and we met and we probably hashed it over for about an hour and a half or so, where we went back and forth talking about what we could possibly do to this legislation to meet those issues that we face. One of the biggest reasons why this is the same draft in front of you, Mr. Chairman, has a lot to do with the fact that we're trying to find a solution to a problem where we're not necessarily receiving a lot of help in regards to what could be beneficial long-term for this industry to be able to be part of the solution. We're not getting solution help. And so hopefully this meeting can serve as that. Maybe we'll get some ideas. I think that'd be great. But also on top of that, arguably this piece of legislation is a policy statement. And that's the biggest end of this, in my opinion, Mr. Chairman, and part of this whole solution, the fact that we've drawn the attention of a national organization that chose not to have their Wyoming folks testify, which is kind of wild. We've drawn the attention of these national organizations because it is an actual issue. I mean, we're not getting the big dogs because this is not for real. And so that's part of the end goal, is to ensure that there is attention brought to this. And maybe this bill isn't the end all catch all perfect piece of legislation, and maybe we'll get there. But ultimately, it's also bringing light to something that nobody else is bringing light to. And so I'm pretty darn proud of this. Pretty darn proud of this legislation as even being out there, because it is bringing light to an issue, and hopefully other states start to pay attention too. And hopefully we can get to a point where we've got a little bit of a kumbaya. I think that'd be great.
Excellent. Thank you, Representative Lindholm. Back to Ms. Long. Go ahead.
Thank you, Mr. Chairman. Just to share with the committee some background, we decided in our working group that we should seek some real life stories of folks who have been on the opposite side of this, because as you may recall in our previous discussion, we were wondering, do we really need to take legislative action? Can't private rights of action in court suffice for people who've been victimized by this? And the answer is we decided to go out and get those stories, and we were absolutely overwhelmed. There were literally dozens of people who wanted to testify because they've had terrible stories. And I apologize to everyone if you're listening. We literally don't have enough time. And we picked 3 people with the priority of, we wanted to understand Wyoming residents who've been victims of this, as well as folks who were not necessarily connected to cryptocurrency, but had their identity theft, identity stolen as a result of a SIM swap. There's some famous stories of this. In fact, Jack Dorsey at Twitter has actually had it happen twice, one of which the person took over his own Twitter account and started sending racist tweets. They did arrest the person in that situation. And then the other one was, it happened to the company, of course, as we know. The infamous Twitter hack last summer started with a SIM swap. So there definitely were a number of folks who had serious financial losses. One gentleman who sent in a letter literally lost his life savings as a result of this. And then there's another one who's suing AT&T for $200 million in punitive damages. who lost $24 million. It wasn't his life savings, but he's a person of means who's been able to underscore a number of through his discovery process. A lot of the revelations about the insecure technology maintained by the telcos has come out of his lawsuit. In other words, that all of the employees in the stores have access to our passwords. They can change our four-digit PIN, and the four-digit PIN doesn't actually help protect us, et cetera, et cetera. So when you hear the testimony, you will hear some of the specifics of their individual situations. But what I wanted to share is we really did have an overwhelming response of people who really truly are looking for help from somewhere and not getting it from the federal level and not getting it from the courts either.
Excellent. Thank you, Ms. Long. Senator Nethercott, member of the working group, did you have anything to add?
No, I think with all the public comment and interest in this, I'll leave it to that.
Great. Thank you, Senator Nethercott. All right. Further discussion before we go to that public comment. All right. Seeing none, let's start off then hearing from our SIM swap testimony. Ms. Kaiser, if you'd join. Hello again, Ms. Kaiser, but please introduce yourself to the committee and the world.
Thank you, Chairman and members of the committee, for having me back for a third testimony today. And thank you, Caitlin, and the working group for all of the work that you have specifically done on this incredibly important privacy law. For those of you that don't know me, I am a privacy and data protection activist, as well as very active in the blockchain space. And for the past many years, SIM swapping has been particularly directed at both blockchain and cryptocurrency thought leaders. Mostly anyone that's ever done a keynote at a blockchain conference has been a main target of this. But now it has become, unfortunately, just as easy to do as it was in the beginning, and therefore is happening to any member of the public because of how insecure the privacy is around your personal information that relates to someone's ability to get a SIM card in your name. So I am a Wyoming resident, and when I was abroad last summer for a friend's wedding in Ireland, I was SIM swapped. I have pretty good operational security, so I was actually surprised that this happened to me, but it still did. And because I was abroad, it took nearly a week for me to get access to re-get access to any of my accounts. I was lucky that my personal operational security is good enough that no money or cryptographic assets were stolen from me, but the amount of time that my time is worth for a week's worth of work of not being able to get back into any of my numerous email accounts, into my bank accounts, into anything that requires 2 or 3 factor authentication that included my phone number, basically meant that I went on an accidental enforced week of vacation, which was a very expensive and terrifying week for me, not being able to actually verify whether I had been stolen from or what had been done within my social media and my email accounts when I couldn't get back in during that time. This has happened to numerous of my friends and colleagues. Some of them have not been as fortunate as me and have had either their life savings or a significant amount of their personal net worth stolen from them, never to be recovered. And I found that it was very difficult for my lawyers to actually have any legal recourse at all for this, even against AT&T, who allowed someone to walk into a place that I had never been before in the United States with my social security number and a picture of me and get a SIM card in my name. So as Caitlin referenced, the infamous Twitter hack started with a SIM swap. And she also referenced a specific case of Michael Turpin, who is a well-known thought leader in the blockchain space, who has been fighting a lawsuit for over 3 years in order to obtain back what was stolen from him due to a SIM swap. He was able to discover, for instance, that AT&T stores your consumer passwords completely insecurely, and that there are two different levels of security. One that's incredibly insecure, that's given to everyone, and if you complain hard enough, then you are given a few extra steps that need to be provided in order for someone to get a SIM card in your name, and therefore likely get access to most of your other digital assets. So I still find that the second level of security is not really enough, given that those passwords are not held securely, and any staff member of any of these stores can be easily bribed or manipulated into giving that information away, even if you are at the extra level of security. So I think it's a pretty big deal. It's definitely happening to people all over the world, and has happened to plenty of Wyoming residents and plenty of top executives for businesses that have located themselves in Wyoming as well. So I think it would be a show of extreme thought leadership to be the first to have a bill that gives everyone this extra layer of privacy and shows the telcos that they actually need to have stronger cybersecurity and data protection enforcement. That couldn't be more important right now, especially in the wake of massive data breaches like Equifax, where people's social security numbers and other personally identifiable information are easily obtained for free on the dark web, or sometimes with simple web searches, depending on what type of information that is. So the idea that someone could do a simple web search, obtain your personal information for free, and go in and get access to everything on your phone, all of your bank accounts, your cryptographic accounts, your and anything else that you have 2 or 3 factor authentication with your phone for, is a pretty scary thing. And right now there's no protection for it. So again, I applaud everyone who has worked on this. This is definitely a landmark piece of legislation, and I do hope we are able to get it through. Thank you.
Thank you, Ms. Kaiser. Questions for Ms. Kaiser? Appreciate the testimony. And I'm sorry about the SIM swap. All right. No questions? Thank you, Ms. Kaiser. Stick around in case we have any follow-ups, please. All right. Let's see. Justin Newton. Can we bring Justin in?
Yeah, hello, how are you?
Great, Justin. How are you?
I'm doing great. Thank you for asking.
Great. Please introduce yourself for the committee, and the floor is yours. Appreciate your time.
Sure. Hi, I'm Justin Newton. I'm a resident of California. You know, a lot of my background has been working in technology and the tech industry. Let me tell you a little bit about my story on SIM swapping. I've actually had the good fortune, I guess for lack of a better term, or bad fortune. I've had this happen to me 3 times with the same carrier. And so I've been through the experience a number of times, and, you know, also worked with a number of like the security measures and mechanisms to try and prevent this from happening. So, you know, even before the first time that this happened to me, I had actually read some of the press around it happening to other people, like some of the stories that have been mentioned in previous testimony. And as a result, you know, because I've worked in telecom and information security and things like that, I actually preemptively called my carrier and asked them to put a PIN number on my account so that changes couldn't be made without, you know, without somebody having that. I was actually also, another way I was really fortunate is each time the SIM swap happened, I happened to almost exactly at the moment that it occurred be looking at my phone and seeing an error message pop up saying that my phone couldn't validate with the network, and, you know, happened to know that that could likely mean that the SIM was swapped, because that was the reason it wasn't able to synchronize and register properly with the network. And so, you know, the first time as well as the other times, I was actually on the phone with my carrier probably within 5 to 15 minutes of when this occurred. And so I was able to work to try and really quickly stop the damage in a way that frankly, I think is not reasonable to expect the average citizen would be able to, understand what that message meant, understand what that means in terms of having to call the carrier and do that. And, I also had to know I had to push the carrier to get me to the right department and division, because I was confident that my phone number was stolen based on what I saw. And so I was pushy about getting pushed to the fraud department right away, so that I could do things like get the other SIM shut off very quickly and work to start to recover my account. And again, I think that those are things that a typical citizen is unlikely to advocate as strongly on their own behalf. And in particular, to know, words to use and the manner in which to be pushy to get through to the department that can actually stop the damage. Another side piece I want to tell you around this, the second and third time that this happened to me, they actually, the bad guys did it just as the regular hours for the fraud department were ending. And so it was actually timed so that it was extra difficult for me to be able to reach the people that I needed to be able to reach to be able to stop them from being able to continue to utilize my number. So they were fairly sophisticated in their approach and attack with me. So the first time the swap happened, I called in and I said, hey, there's what I think this is what happened. There's fraud. They shut it down right away. I said, well, hey, I thought I had a PIN number on my account so that people couldn't just call in and do this. And they said, well, yes, you did turn on the PIN, but the PIN was set to optional. And I've never heard of a security feature being optional before once you turn it on, that you could turn it on, but someone could be like, no, I just don't want to be asked that question and just get by it. And but somehow they had some setting like that even after you tried to secure your account, it didn't really count. So that was the first time it happened. I had also proactively secured a lot of my accounts to say, don't use my phone number as a security or a recovery feature. And so, I went in and checked a lot of my accounts right away, and most of them were actually locked down and the bad guys weren't able to get in. So they did not able to get at my financial resources or anything like that. That was great. What they were able to get into was one of my Google accounts, a Google email account that I hadn't properly locked down, as well as my Twitter account. And they went into those and they, very quickly changed the email address that was associated with them, changed the phone number that was associated with them, and those sorts of things, so that even in the maybe less than 10-minute window that they had before I recaptured my number, or at least blocked them from having my number, it actually took about a day and a half to get it back, even though I had it blocked within about 10 minutes. But even in that 10 minutes, they had locked me out of those accounts completely, so that my email address wasn't associated with them. My phone number wasn't associated with them. They'd moved it to another one. And actually in both of those cases, reaching out through the normal channels at both Google and Twitter, they wouldn't believe that I was me. Somehow they weren't able to I don't know, but they didn't do the proper looking to see that look, these email addresses and phone numbers have been associated with it for a decade, and this one has been associated with it for 15 minutes. Maybe there's a problem there. The only way I actually got those accounts back is I literally had former employees in management positions at the company. And so I was able to reach out to those former employees and get them to vouch for me and say, no, I know this really is him. I've known him for 25 years. It's really the person. And so I was able to get my accounts back that way. The reason I want to highlight that just really quickly is, that's not going to be something, again, that's available to the average resident of Wyoming. And so it's going to be much more painful for them. The last thing I want to just touch on really quickly, because I know this is running a little bit long and I don't want to take too much time. The second and third time my account was stolen, it was actually stolen by someone physically going into the store, as Caitlin talked about, and getting an employee to override the system. In one of the times they actually, brought in, as Brittany had talked about earlier, Ms. Kaiser, the, identity document. The system actually scanned the identity document, and the name that came off it was the God. And it still, everything went through okay, and they gave them my account and locked it up. And so, I definitely want to agree with some of the things that have been said here, that, the proper things aren't being done to secure and protect these accounts. As a very sophisticated user, I was unable to block these attacks from happening, even by engaging all of the security features that I'm told were available to me. And the repercussions for me were painful, but had it been someone that was not sophisticated, savvy, and literally watching for it to happen, it would have been much, much worse, because they, instead of resetting an old Google account and my Twitter account, they would have done my bank account and my trading account. And they would have taken those over, and they would have taken some other things over that, had a much bigger impact on me than not being able to tweet for a few days.
Excellent. Thank you, Mr. Newton. It's very informative. Questions committee. Any questions for Mr. Newton? Senator Nethercott.
Thank you, Mr. Chairman. Mr. Newton, I think you're kind of the perfect guy for us with your level of expertise and your experience. And so as you look at this bill, the bill is pretty simple in concept, but as you think about it, are there any specifics that we can add, as safeguards or procedural steps that you think would be a good idea? And maybe give you a minute to think about that and we can come back to you. But I think that your insight and sophistication are particularly important here.
Maybe if you could give me a minute or two to think about that one, and maybe take a moment to just re-review it one more time, I would be happy to provide that feedback if I have anything.
Thank you, Mr. Newton. Go ahead, Senator Nethercott.
Yeah, thank you. And maybe kind of more specifically, what steps they should take when they've been notified, something very specific and action oriented, that upon notification, the company shall do these types of things. So that's what I'm thinking.
Okay, great. Thank you for that feedback. I'll definitely take a look at that.
Thank you, Mr. Newton. Thank you, Senator. Any further questions for Mr. Newton? Further questions? All right. Seeing none, thank you, Mr. Newton. And let's see, our final case study is Jesse Matchey. Jesse, welcome. Please introduce yourself to the committee and tell us about your story.
Hey there, Chairman, Senators, Representatives, Caitlin, ladies and gentlemen. I appreciate the opportunity to share my story. A brief background on myself. I grew up in rural Wisconsin, had a financial planning practice for about a decade until I moved to Arizona to pursue Army aviation, where I was a Black Hawk pilot, commanded a medical evacuation unit, and managed the Arizona Army National State Aviation budget until I was rear-ended in a car wreck and had spine surgery and was subsequently retired after 15 years of service. Currently, I'm in an executive MBA program at ASU. On December 3rd, while I was doing my schoolwork, my phone suddenly lost service. I attempted to call my cell phone provider, T-Mobile, but my phone flashed something that didn't make any sense to me. Wi-Fi calling disabled. Please contact your provider. Unlike some of the other speakers, I didn't really have any background in some of the stuff that you guys are dealing with. So this is somewhat foreign to me. I restarted my phone without any resolution. So I used my girlfriend's phone to call my provider. At the same time, I saw an email notification on my laptop. Your Apple ID has been reset. I vaguely understood I was under attack of SIM swapping crime, but my first place to end it was my phone provider, T-Mobile. I remained on hold with them for 37 crucial minutes while the avalanche of password resets from various accounts flashed on my screen. T-Mobile finally froze my SIM 7 minutes after that 37-minute call. In that time, we used my girlfriend's other phone to freeze my bank accounts. These entities also had me on hold. Once the SIM swappers had my SIM, my fingerprint to access my phone, my password to my Apple ID, my Microsoft Outlook, Hotmail, Google, University email, Coinbase, Dropbox, and my banking, amongst others, were all bypassed. Anything that had my cell phone number, my email address as my backup recovery option was rendered useless. Even worse, they all worked against me and locked me out. Security questions did not save me. It was as if I had handed my physical cell phone with it unlocked and every password in hand to criminals. This includes handing them the ability to send, receive every incoming or outgoing text, email, call. If they didn't have the username or password to a particular site, they could use the "I forgot my username and password, please email or text to my designated phone or email," which went to them. The criminals either duped T-Mobile to transfer my SIM to their phone through social engineering, stalking, collecting data, or used to convincingly pretend they were me, or there's a bad actor within the phone company who sold it or was part of this scheme. Currently, I still don't know which. This was highly coordinated, meticulously planned. Once they got access, it was like an avalanche. Not only did they gain access to these accounts, but they also reset passwords and locked me out of everything along the way. Because they accessed my Microsoft 365 through use of my email account, they were also able to set up forwarding rules to preemptively intercept any incoming or outgoing emails that would later be used to attempt to recover these various accounts. So they had access to everything. While in my Office 365, they gained access to my OneDrive, which is something I didn't even knowingly use, yet it had a copy of my girlfriend's front and back driver's license, which she had scanned years ago. The criminals sent me an email from my account to me with her driver's license images attached with demands for money, along with threats to, in their words, rape my family. Because of a real estate transaction I've been in the midst of, images of my driver's license, military ID, social security number, tax records, and banking info had also been compromised. By intercepting emails, they were attempting to shape my recovery efforts and bypass the last line of defense that was preventing some of their ability to drain my accounts by attempting to disable my two-factor authentication Google app. Based on viewing of their search history within my Outlook, the hackers also attempted to find the recovery seeds to be able to disable this. So while all this was ongoing, I reached out. I mean, I was trying to find help anywhere. I reached out to local police who referred me to the FBI, who referred me to the FTC to only fill out an online form, obviously not helping me in real time, which I've not heard back on other than an auto response. The various tech companies needed for assistance in order to be able to stop this avalanche often don't have real-time customer service reps available. They'll send you to a virtual chat assistant, or they don't have the methods, if you do reach somebody, to be able to aid in freezing everything. So when I was finally able to reach any of these entities, many of them did not even understand what type of crime this was. It was even unknown to them. And even the FBI guy I spoke with said he assumed this was along the lines of the Nigerian prince phishing scheme, requesting my banking information to send $10,000. I was just appalled. Afterwards, I contacted my phone company to initiate a SIM port block with extra requirements such as physically presenting in person with a PIN in order to transfer a SIM in the future. However, when I went to the physical store to set up a new phone number and transfer my previously stolen frozen SIM back to my phone, this was 5 hours later, they did not even request the 6-digit PIN that they had given me over the phone. The rep merely glanced at my ID while I had a mask on and proceeded to give me back my SIM. My phone provider at first told me they had no notes recorded on how this SIM swap actually occurred. In subsequent calls, because I was very upset over this and knowing what some of the implications are going to be, they suggested that somebody used a fake ID with my information. However, I never lost my physical driver's license. After asking if they referred the fake ID crime to the police, they could not tell me. T-Mobile could not tell me which store location this had allegedly occurred in. The attackers were either dispersed throughout the country or they used IP address hopping and fake phone numbers from around the country to harass me. So I don't know where they were actually even doing this from. You know, my fears could go anywhere. From, are they close to my mother's house? Are they close to my house? In my previous professions of finance, military, and federal government, people undergo extensive background checks and have security clearances to handle PII, which often poses much less of a threat and has less implications than these telco companies possess. What are their checks and balances? And lastly, a few points of note, whether it's been OPM or other websites that have breached my PII in the past, they all focused on an insular view of perhaps like a single credit card is stolen, but they don't look at the compilation of all the one's individual identity to be used in like a SIM swap or all the lifelong problems afterward. Additionally, each of these tech entities provided no 50,000 feet overview of how all these failures interact and compound on each other. And there was no real-time ability to stop any of this. So since attempting to safeguard and reset everything since, I discovered how easily, even still, as I'm resetting everything and changing passwords and setting up more two-factor authenticators, all of these entities have the ability for me to use the personal information that was stolen from me in my email. The hackers, criminals, whatever, they can go in and they could easily pose as me and get past all of that. So I'm not sure the solutions to all of this. I really appreciate that you guys are exploring this, and pending any further questions, with that I close.
Thank you, Mr. Matchey. Appreciate that testimony. That's wow. Folks, questions? Yeah, go ahead, Representative Lindholm.
Thank you, Mr. Chairman. And first off, Mr. Matchey, thank you for your service. It might have been a little better if you would have joined the Navy. Being a Navy man myself. I forgive you for the Army-Navy game, by the way. You guys really hurt my heart. So in regards to how this is shaken out, I mean, this has been much more than just a digital asset type thing. I mean, they took multiple different parts of your life in that regard. And have you changed carriers because of this? Did this move you away from them? If you don't mind me asking, you don't have to answer that.
Yeah, no, that was one of my first instincts. I opened up a second phone line through them and used that as a I'm not using it for calls or setting it up with any websites or anything. I thought about going to another carrier, but after some research on it, this every waking hour for the past couple of weeks has been spent trying to figure this out. I don't know that that's the solution. Other carriers have the same problems. And so if you go to the next one, you're kind of looking at the same issue of, well, now you are at tier one, starting all over. They don't have the red flags and alarms on your accounts. And so you don't have that secondary protection set up. So I don't know what the answer is. I really wish I had a manual that said, here, do all of these things and you will for certain be concrete proof, but I don't know.
Yeah, I think you said follow up.
Yeah, follow up. Go ahead.
Yeah, thank you, Mr. Chairman. One last question. Alphas, Limas, Mighty Mikes, what'd you work on? What'd you fly in?
Mr. Matchey.
Alphas and Limas.
Gotcha. Right on. Thank you.
Thank you, Representative Lindholm. Additional questions for Mr. Matchey? Any additional questions? Seeing none. Thank you, Mr. Matchey. Appreciate your testimony. And again, stick around for a few minutes if you can in case we have any follow-up.
Certainly. Thank you, guys.
Thank you. Ms. Long, sorry, I was
Thank you. Yeah, you were on mute. Thank you. I would like to underscore for the committee's benefit that there are a couple of letters from folks who would also have been able to give compelling testimony. And again, I thank everyone who did respond to this and offer to testify. Some sent letters. Those letters are stunning. One literally lost his life savings through this and is actually pursuing litigation. And he actually talks about how difficult it's been litigating against the telecom companies. They've thrown the book at him. And the other piece of this is he actually started a victims organization, and I think it's called, Stop Sim Crime. And there's a lot of resources on that website. I just want to make sure to call him out because we weren't, again, able to get everybody in here. Michael Turpin as well, the one who's revealed a lot through the discovery, has a letter talking about what's been revealed about the lax practices of the telcos. So it gives you some sense of just how broad the problem is. Thank you.
Thank you, Ms. Long. I appreciate the diligence in getting this testimony put together for us. This is, I think it's very compelling. Any additional questions or discussion before we go to additional public comment? All right, seeing none, let's go to our public comment list. We have a number of participants. Let's invite Lisa McCabe or Maccabee from CTIA. I'm sorry, I don't remember which way is the correct pronunciation for that. Lisa, welcome, and please correct me on the pronunciation of your last name as you introduce yourself.
Hi, Lisa McCabe with CTIA, the Trade Association for the Wireless Communications Industry. Thanks for having me here today. And I'm sorry to hear about the stories that were presented. The wireless industry takes SIM swap fraud very seriously, and they have tools and procedures in place to help protect consumers. Wireless providers are constantly innovating and improving their internal processes to stay ahead of these bad actors. The industry has taken and continues to take a variety of tactics to stop SIM swap fraud. These include offering wireless account PINs and the ability to lock or freeze wireless accounts to protect against unauthorized access and changes, employing multi-factor authentication when account changes are requested, training employees to identify signs of a fraudulent SIM swap request, providing additional security tools to further protect accounts, as well as online instructional videos on how to use these tools, leveraging technology solutions to identify and combat unauthorized SIM swaps, working with financial institutions on ways to prevent fraud via SIM swap activity, and working with law enforcement to bring actions against SIM swap fraudsters. Wireless provider customer service representatives in stores, online, and on the phone don't have access to customer password and PIN information. We have concerns that this legislation would place a higher level of scrutiny on wireless providers than any other business operating in the state. And this is unfair and unnecessary. The Wyoming Attorney General, through its Consumer Protection Statute, and the Federal Trade Commission and the Federal Communications Commission are already able to police unfair practices by carriers, and these laws are being tested in the courts. Passing legislation would create a patchwork of disparate and static regulation, which is difficult and could also hinder the ability of providers to pivot in order to thwart harmful techniques that bad actors could use in the future. We also have concerns that a bill like this would cause regulatory uncertainty for providers, which could act as a disincentive for investment. I think it's important to note that this type of issue is one that is a global issue with respect to identity theft on the whole. In many instances, the apps on a device, any type of application that a customer downloads, the authentication within those apps is nothing that can be controlled by the wireless provider. So I think, we do everything we can to try to prevent SIM swaps and are constantly making changes to effectuate those, including social engineering training on the behalf of our customer care reps, and looking and monitoring for data patterns for agent behavior to try to make sure that this doesn't happen in the future. And I'm sorry to hear about the cases that were raised here.
Thank you, Ms. McCabe. I appreciate the testimony. Any questions for Ms. McCabe at this time? Any questions? Ms. McCabe, I have one with regard to consumer protection in the state of Wyoming and through the Attorney General's office. How many complaints, and you may not know these numbers, but do you have any idea how many complaints have gone through the AG's office, or what actions our consumer protection division have taken with regard to SIM swaps in Wyoming?
I am not aware.
Okay, thank you. Appreciate that. Additional questions? All right, seeing none, thank you very much. Appreciate your testimony, Ms. McCabe. All right. Next on our agenda is Mr. Brian Woody with Union Wireless. Mr. Woody, you are up. Welcome. Please introduce yourself to the select committee, and then the floor is yours. And you are still muted, Mr. Woody. We've all done it. Uh-oh, this is a bigger tragedy. I can't hear you still. Am I the only one? No, can't hear him. Okay. All right, I'm starting to hear noise.
That better?
Yes, it is. We can hear you now, Mr. Woody.
Okay. Thank you, Mr. Chairman. I'm Brian Woody with Union Wireless. We're a Wyoming company, started in 1914 in Mountain View, Wyoming. We have a spectrum across the state. And currently in Wyoming, we employ about 270 employees. We do both wireless and wireline broadband. And I originally was kind of against this bill. I think that something does need to happen for these customers. I appreciated the testimony that was brought earlier, because it is a problem. The problems I see in the bill right now is there's not a lot of definition to give us any kind of guidance of what we need to do to help protect our customers. Union cares very deeply about its customers. That is the lifeblood of the company, is our customers. Without our customers, there's not a purpose for us to be in business. We feel like we take care of a lot of the issues here with consumer proprietary network information, with policies and procedures and training for any customer rep or any employee in the company that touches a customer account. They have to do training quarterly to try to combat this. Just keep it top of mind to them. The rest of the company has to go through annual training, but for those that have access at all to customer information, have to do training quarterly for CP&I. So that's kind of where we sit with this bill. The reasonable actions on page 3, line 8 of the bill, we'd like to see that better defined, to give us a better view of what we need to do and what more we need to do, and to know how we can protect our customers. So with that, Mr. Chairman, I take any question.
Thank you, Mr. Woody. Appreciate your testimony. Questions? Representative Lindholm.
Yeah, thank you, Mr. Chairman. Mr. Woody, I really appreciate that testimony. And Union Wireless has been one of those Wyoming entities that has stood out in front and taken care of their customers. And I can't say how much I appreciate you guys. I've never heard a bad word about Union. You guys do a good job. And I certainly haven't heard about any SIM swaps happening. So, I'm not trying to throw stones at other companies, kind of a little bit, maybe I am. But in this regard, moving down the road, I really appreciate your testimony, because the question was, we need to know what we can do to bring some peace of mind in this regard. That's what I got from you. And I appreciate that, because I've had that same conversation with other entities, and I've been basically told how stupid I am for even thinking this way. And so I appreciate that this is part of the conversation. I think this is how we can get somewhere where maybe it's not even a legislative change. Maybe it's nothing. Maybe hell, it's a letter from this committee to union or to wireless providers saying we expect some responsibility. And the fact that you're willing to go down that road means a heck of a lot to me. I don't, and honestly, I don't know it's such a different aspect. I guess in regards to, do you feel that Union Wireless as a carrier, your employees have a responsibility to ensure that security measures are above and beyond what they were 5 years ago? Do you feel that it has changed?
Mr. Woody, go ahead.
Mr. Chairman, Representative Lindholm, I think that over time, of course, we evolve, and like any entity, no one's perfect. On the CP&I realm, granted, none of these that I know of turned into a SIM swap, but it was a violation of our policies and the laws concerning consumer network proprietary information, where we've had employees divulge information. In those, the first one that ever happened that we knew about, unfortunately, it happened. The employee that actually created it brought it forward. We investigated it. We did all the things that we're supposed to do as a carrier, which is report it to the FCC, report it to the FBI, and report it to Homeland Security. The FCC, the FBI, and Homeland Security did nothing. We terminated the employee because they'd been through training. They'd been shown what they're to do and what they're not to do. And we take it very, very seriously. And just for the committee and that, it was my daughter that was the employee. And we're a family-run company. We're family-owned. And that was an unforgivable mistake. That's how seriously we take it at Union. And I take it the same way with every other employee we have. So that's where we sit. I want to know, I want to make it better. I want to be able to protect our customers to the greatest extent we can, because they are part of our family. We take care of them. We give them the service that they need. So I hope that answers the question.
Thank you, Mr. Woody. Feel free to follow up, Representative Lindholm.
Yeah, thank you, Mr. Chairman. And Mr. Woody, I really appreciate that testimony. In regards to possible solutions moving forward, in regards to appropriate security measures being taken or what have you, I'm not in the wireless field. I don't know anything about your business, besides being the chairman of the committee that handles you guys for the last couple of years. But I guess as a comparative for me, on some of the businesses that I have, when I go onto a job site, I have to be insured. My customer demands that. And that's because myself or my employees might screw something up on their property or with their property. And if that is the case, at that point, that's why I carry insurance. And that insurance it will be used. Now, thankfully, knock on wood, I haven't had to experience a run on my bond yet, but I do think that I don't know if that's the future. I don't know what that looks like, but where we're going to have to be very careful, whatever we do, committee, and for Mr. Woody, whatever we do will cost the customer. Whether it's a regulatory change saying you have to apply different security measures, or you've got to be willing to take fiduciary responsibility for your employees' actions, guaranteed that will be passed down to the customer. And that's, I don't say that as like a negative thing. That's just business. That's how it works. But I guess as a follow-up, would you prefer, Mr. Woody, something like what we currently have in the legislation that speaks directly towards security measures, or would you prefer something in regards to some type of ability for fiduciary responsibility to be mentioned?
Mr. Woody, go ahead.
Mr. Chairman, Representative Lindholm, I'm not certain. I think that there's definitely something, the fiduciary part, we're already there in some respects, because I still see this as a really kind of a breach of CP&I. If one of our employees hands someone that is not the customer or the account holder or authorized user on the account a new SIM to replace their old one, and it's not that customer, then yeah, we have responsibility there. Our employee has responsibility there. And where I haven't seen the FCC, FBI, or Homeland Security do anything at this point, and they've had plenty of time. I think the example I gave you was about 4 years ago. That is definitely something, but not having any idea of how or what's expected to give us kind of a benchmark of what we need to do, because the financial side of it is one thing, and slapping us with fines is generally the way it's done. However, that doesn't necessarily fix the problem. This is something we need to figure out how to fix the problem.
Mr. Woody, I have a follow-up question on Representative Lindholm's, and I appreciate your testimony as well, and I appreciate the good intentions of trying to work with us and find a solution, and that's very welcome, and we'll do our best to work with you on that. And as far as the circumstances you give, I also believe that it's very meaningful to you, because you want to keep those customers, that just from the standpoint of being a good business and a good organization, you want to make sure that you don't have a SIM swap occur. And then you've got these reporting requirements. But just from a financial standpoint, I'm just sort of curious what it would cost you. And I don't see any actual cost. If a SIM swap occurs and bad things happen, do you really accrue any costs? Or maybe a few more human hours of time to deal with it, but there's really not anything else out there, is there?
Mr. Chairman, unless the FCC gets involved and does something in that direction, you're right. There isn't a lot more cost. A SIM card today, our cost on it, $5-6 of material cost, plus the labor and storage and all that stuff. So, it's not material in that respect. From what I understand, the FCC could put up a forfeiture of upwards of 7 figures on the low end, that is real money at that point. But at the same time, it really still hasn't fixed an issue. And I'm not sure that there's more technology we can apply to this, or whether it's ensuring that everyone's using the proper process and procedure and that they're actually following it, and making sure that their employees follow it, and really make sure that the audit or what have you to ensure that this doesn't happen to customers, no matter what carrier they're with.
Mm-hmm.
So,
thank you, Mr. Woody. Additional questions for Mr. Woody? Go ahead, Senator Dockstader.
Thank you. Appreciate Mr. Woody coming on board, Mr. Chairman. The one advantage, and the SIM card issue isn't really, that doesn't help that, but the one advantage for our local carriers is we don't have situations where you call in and wait for 45 minutes. I have a phone from his company, and I've called and had immediate help. I walked into his offices in Mountain View, and they switched out a phone within the first few minutes of me being there. And that's the opportunity that comes with having local providers. It doesn't necessarily address the SIM situation, but there's a quicker response time from our local providers. I guess it's a statement more than a question, Mr. Chairman.
Just fine. Thank you, Senator Dockstader. Additional questions or discussion? Committee? Anything for Mr. Woody? Seeing none, Mr. Woody, thank you so much for your testimony. And again, stick around. We might need to bounce some things off you if you'd be so kind. I realize it's getting a little bit late, but we'd appreciate it. Thank you.
Thank you.
All right. Now, Mr. Wood, well, next on my list is Verge body felt from Union Wireless, but do we have that testimony here, Mary Beth, or was Mr. Woody speaking for Union Wireless sufficiently?
Mr. Chairman, I believe Mr. Bodyfelt is not in the meeting, so I would assume that Mr. Woody was encompassing the public comment.
Yep, that makes perfect sense. Thank you, Mary Beth. Appreciate it. Then with that, I do see Ms. Zerga. So Ms. Zerga, please, you know the drill. Introduce yourself and welcome to the select committee.
Thank you, Mr. Chairman. Liz Zerga. I represent Silverstar Wireless. Just a couple of things. One of the things interim is there's a couple of issues here. One is why would carriers, what is the balancing of interests here? Is there a balancing of interests? So customers who legitimately need to have their SIM replaced have an interest in making sure that it isn't extremely onerous to do that. So come into the office for my local carrier, present your ID. Oftentimes you're already known to them. The other way that occurs, and I said that Silverstar can require a password, so a password or come in person. And so if the person calls up and says, I lost my phone, I've got a new phone, I need to get it activated, I need my account, they're the legitimate user. And Silverstar says, what is your password? And they type it into the phone or provide it. And so then they get activation. Versus you have criminals who have done, just terrible things to the folks who have testified. So a fraudulent SIM swap. And so there is a balancing responsive to its customers. They care very much about the customers. They have training. They have procedures in place. I've talked about them to prevent fraudulent SIM swap. That's not to say it can't happen. Criminals are innovative. They're smart. And they try to stay one step ahead of every single thing that any carrier or any provider tries to do. So that brings us to this bill, and that's where I want to focus on. Silverstar has almost an identical concern as that expressed by Mr. Woody. Is what Silverstar does reasonable? Because this is a prohibition against, it says that a telecommunications company shall take reasonable actions. Silverstar thinks what they're doing is reasonable, but is it? And is there a safe harbor? I don't think that we can know that. So we have this standard under which it fits into a regime that's already in place here as to fraudulent and deceptive practices. They are very there are things like you will not false. It's very clear conduct that's prohibited. But when we get to this bill, the conduct, what you have to adhere to not have this be a fraudulent and deceptive practice, you can look at it and say, it's not black and white, not like the other provisions. So you look at it and you go, is my company's conduct sufficient? I don't know. I really don't know. And that's a problem. The other concern that I have about this bill on page 3 is it shifts the burden to this carrier, in this case, it's a small carrier, to establish a negative, to establish that it was the action of the telecommunications subscriber that allowed or caused the SIM card swap. So one of the ways SIM card swapping, can occur is because the person gets access to the PIN, either because they live with the person or they lived with them, because the person had written it down and the person burglarized their house and got access to it, or because the person, for whatever reason, had it stored on a computer or something, and then somebody breached their computer and got access to it. Will the phone company know that? No, the phone company isn't going to know that. We can't prove how these people got access to things that they end up with. But sometimes the person who is the victim knows about these previous things. Oh yeah, that's my ex-boyfriend. He had access to my account. So that's an issue. You're shifting the burden to a carrier who isn't going to know. They aren't going to know these things. So those are my concerns about the bill. I do appreciate and understand, and I empathize with the victims of SIM swap. It is a real thing. I just don't think this bill is a good vehicle as drafted to address it. And what can I take back to my carrier and say, yeah, you're good? No, you're not good with respect to this. So I'd stand for any questions.
Thank you, Ms. Zerga. Representative Lindholm, go ahead.
Yeah, thank you, Mr. Chairman. Ms. Zerga, it's always great to see you. They're going to be our last little rodeo, and we're going to disagree on it, so it'll be good.
That's okay, Mr. Chairman.
Ms. Zerga, so first of all, I really appreciate having some local lobbying support stepping in. Maybe the goal, maybe what we should do here is just say, because it gets down to the point, right? What we're trying to knuckle down here isn't on somebody losing their password or writing it down or something like that. What we're knuckling down on here is where some of your customers have allowed their employees and taken no responsibility for it. Their employees have violated the law while they're at work on behalf of your customers. That's what we're getting down to. So maybe it'd be simpler just to put in a piece of legislation that if through investigation by any entity, any type of enforcement agency finds that it was your employee that committed this, then your customers would be 100% liable for any damages. Maybe that would be the simple way. Right now, currently, we're asking in this piece of legislation that there's higher security standards set in place so that we can help prevent this. Because we're not talking about somebody losing their password. That's their own damn fault. What we're talking about is employees of these entities partaking in this fraudulent type activity and causing these things to happen. The other stuff I completely understand, Ms. Zerga, and maybe that's our fault for not being more clear in the law, but what we're really trying to go after. So would that be more of a welcome piece of legislation saying that if through some type of enforcement agency investigation finds your customer to be at fault, they're 100% liable?
Ms. Zerga, go ahead.
Mr. Chairman, Representative Lindholm, just a couple things. So when you were using your company's employees are the ones at fault, I'm assuming you're not meaning Silver Star per se,
no,
because
no.
No.
I'm sorry, Ms. Zerga, I should have been more specific. Please
Yeah. And so what you would do instead is have a bill that makes the telecommunications company 100% liable if their employees engage in a criminal activity, fraudulent criminal activity, and join with these SIM swappers to sell or to give away SIM. Would my company like that bill better than this bill? I know they don't like this bill. If you draft up that bill, I will take it to them and talk to them about it. That is a much different bill. That is a much more targeted, much more different bill. But it's one of those things, and I know you can appreciate this, until I see the bill and see exactly what it does, I can't commit as to what my company thinks or doesn't think about it.
Thank you, Ms.
And
Zerga.
I appreciate you very much. So,
Representative Lindholm, follow up?
Yeah, thank you, Mr. Chairman. It's a tough deal. I think the original intent of this bill was trying to be a little bit more of a carrot. That, hey, we need to look at this, guys. This is a very serious deal. I mean, you heard some of the testimony from some of these folks. We had a veteran. We had a Wyomingite. We had somebody that this has happened to 3 times, and it wasn't through any fault of their own besides being a customer to what could be argued a company with very lax security standards that are, I guess, essentially allowing it to happen. And the only recourse that they've got is just to go to court. And some of these people certainly have the means to do that, but some of these people do not. I mean, if you look at the standards on a national level or even a worldwide level, as far as the unbanked out there, it's a huge population. And so what are those people that are unbanked relying on in 2020? They're relying on their cell phones. They rely on Venmo. They rely on PayPal. They rely on all of these different types of new forms of technology to hold their assets, and they don't even have a bank account. So their entirety of their wealth, they're carrying around on their device, and their only recourse is to go hire an attorney. And I love attorneys. I really do. Some of them are my best friends in the world. But some of them are pretty expensive too. And so that gets to be pretty tough. I mean, how do we justify that? How do we, as a state that's trying to protect our consumers, look at our consumers and say, as a legislative branch, how do we look at our consumers, at our voters, and say, your recourse is in the judiciary branch that is notably pretty expensive? That's the problem.
Go ahead.
Mr. Chairman, Representative Lindholm, that can be said of a lot of instances. This is not the only arena where that happens, where you think my solution is I need to go get an attorney and I need to file a lawsuit, and it's expensive. I will tell you that in the lawsuits that have been filed, that I've seen, and I'm just a observer. I've looked through or thumbed through some of the complaints that have been filed in some of these big cases in this arena, and every one of them files a claim seeking attorney's fees under, a federal CP&I claim. They all do. And so is that the answer for the, it's a costly endeavor? Maybe that is the answer. That remedy is certainly there. All I can tell you is the carrier I represent takes this very seriously, and they think that there are federal laws that have shown up in these lawsuits regarding protecting CP&I that they think, they could be subject to if they had one of these things happen and they were at fault in some way. Like I've said before, these are very fact specific. In some instances, it is the carrier's fault. In other instances, not so much. So.
Thank you, Ms. Zerga. Any follow-up, Representative Lindholm? Any additional questions for Ms. Zerga? Senator Dockstader.
Thank you, Mr. Chairman. So Ms. Zerga, then your company, which is a Wyoming-based company, there's no part of this piece of legislation that they like?
Ms. Zerga?
Mr. Chairman, Senator Dockstader, I understand the intent of it, but no, we do not like the legislation. The intent I understand and I can empathize with, especially the part about the employees. But this particular legislation, no.
Thank you, Ms. Zerga. Representative Greer.
Yeah, thank you, Mr. Chair. Mr. Chairman, I apologize, but I've got to log off. I understand we're probably going to work this bill. I understand we don't take proxies on interim committees, but just for the record, for those people that want to lobby me or work me over, which everyone just does freely, I realize. But no, I'm a strong no vote on this bill. I realize that won't matter for the matters of passing this forward, but just so the rest of the committee is ready when we hit the House floor. Okay. I apologize.
No worries, Representative Greer. And we tried to reschedule this for tomorrow, recognizing that we were going to go a little bit late if we ran it tonight, but conflicts of schedules were such that we couldn't do it. So here we are, and my apologies to you.
No, I understand this. And I just, these 2 days are tough. I'm going to be tough tomorrow too, same way. So thank you, Mr. Chairman.
Yep. Thank you. Appreciate your participation. Take care, Representative. All right. Any further questions for Ms. Zerga? We've got one more. Thank you, Ms. Zerga. Appreciate your time. And our final potential testimony is from Mr. Robert Ross. If Mr. Ross is here, Mary Beth, do we have Mr. Ross?
Mr. Chairman, Mr. Ross has advised that he is following along with the YouTube. He did provide written testimony. I have uploaded it. I believe it is Appendix 1103. But we do have an additional public comment from Mr. Allen.
Excellent. Thank you, Mary Beth. Appreciate that. And Mr. Allen, let's.
And Mr. Co-Chairman.
Yep, go ahead.
Mr. Allen, if you could be, because the hour is late.
Yep.
If you could be succinct and not repeat anything that's already been said, that would be great for everyone. Thank you.
Yep. Mr. Allen, best 2 minutes here.
Yep. So I heartily agree that the telecoms have the majority of the problem and responsibility. On the other hand, this is a multi-party thing. Twitter, Coinbase, Gemini, et cetera, should not be using phone-based 2FA because of its existence. Alternatives, better, more secure alternatives have not been made. They are almost as responsible as the telecoms, because telecoms have other responsibilities. Let you get your phone back when it's returned and whatever. So I am very supportive of tightening up on telecoms, but you can start saying very easily, starting immediately at the passage of this bill, no Wyoming IT contract will be allowed to use, new ones will be allowed to use phone-based 2FA, and then 2, that all existing contracts have to be phased out of the use of phone-based 2FA. The national security, NIST, the National Institute of Standards, said 5 years ago that you shouldn't be using using phones for 2FA, and we're still doing it. And it's irresponsible for any CSO to still 5 years later be using phones. So yes, the consumers are getting the brunt of this, but it just shouldn't be done. You shouldn't be using a phone to a 2FA, and because we keep on not stop doing it, people will keep on using it. So we just got to kill phone-based 2FA, period. Anyhow, that's my testimony. Hope I kept it under 2 minutes.
Thank you, Mr. Allen. Any questions for Mr. Allen? All right. Senator Nethercutt, go ahead.
So what is used in the alternative?
There are a number of other mechanisms. There's one-time passwords. There are various, QR-based mechanisms. I personally, print some of those QR mechanisms on paper so I can do it if my phone is stolen. There are, half a dozen different approaches. All are superior to SIM-based phone 2FA. But the bottom line is, people don't want to use them because it seems so simple to use the phone-based one, despite all of its known security risks and such. So there hasn't been as much innovation. There could be a lot of more innovation in that area. If again, there's legitimate interest in making phones be able to recover when you lose them. There's legitimate interest in being able to port your phone out from T-Mobile to AT&T or whoever you want. So, all these competing interests make it real hard to force things on them without causing other problems. So just don't use 2FA on a phone.
Yeah. Thank you, Mr. Allen. And to be clear, Mr. Allen, when you're saying on a phone, you mean SIM-based, and that the smartphone applications of a 2FA authenticator app that is tied to the specific hardware is a very different technology. So
that is correct.
When Mr. Allen's saying don't use a phone, he means the SIM basis and the phone number. Yeah, that's an important clarification for all those that are listening who are freaking out about their app that they thought was secured. It still might be.
Yeah, Mr. Chairman.
Representative Lindo.
Let me break that down a little bit more cowboy. That's where you get a text message from a company, and it's got a number that you got to put in whatever application you're using. That's bad. 2FA that's good would be like, I'm not propping up Google Authenticate, but that's not a bad one.
Yeah.
Yep.
Bingo.
And just, right now, Wyoming does use, some of these 2FAs in its own contracts and work. So and that's something you absolutely have control over. You just say you can't do it anymore, and you got to phase out if you are. That's a nice starting signal. Cheap.
Thank you, Mr. Allen. Appreciate it. Additional questions for Mr. Allen? All right, seeing none, thank you, Mr. Allen. All right, that is it for our public testimony. To the best of my knowledge, Mary Beth, we haven't missed anyone?
You have not, Mr. Chairman.
All right, public testimony is closed. Back to the committee. Committee, what's your pleasure?
Move the bill.
We have a motion on the bill. Is there a second? I see a second. So the motion was from Chairman Olson. The second that I saw was from Representative Lindholm. All right. Any discussion before we get into the bill? Seeing none, let's, excuse me, go ahead, Ms. Long.
Yes, just real quickly, Mr. Chairman, thank you. I think we heard a lot of compelling testimony today. The idea behind this bill is to shift the burden a little bit more in favor of the consumer. And it is designed to make it easier for the consumer to have recovery in litigation, because the recovery so far has been almost zero that I'm aware of. Every one of the cases that I'm aware of where somebody did actually seek a remedy in the judicial system, it's literally been mired in years of litigation defense tactics by the telcos, and it's been very expensive. The average person, of course, can't take that on. So what we're trying to do here, and the reason why we are not prescriptive, as Ms. Zerga was saying could be an alternative, is that we don't know what security standards are going to change over time, and we would rather just shift the burden of proof back away from the consumer, because right now it's not working. Thank you.
Thank you, Ms. Long. Additional comments before we get into working the bill? Go ahead, Senator Dockstader.
Thank you, Mr. Chairman. Good discussion. I also have concerns that we have two Wyoming-based companies who said this isn't going to work. And in a world of huge companies that I may suggest that don't really care, we have two Wyoming-based companies that say this isn't working at all. And we essentially bypass our Wyoming companies trying to take on a bigger picture. I'll be a no vote.
Thank you, Senator Dockstader. And we can get to further discussion, and maybe we can work through some of these concerns. But if anyone else wants to raise concerns before we work the bill, please feel free. All right. With that, we do have a motion and a second on the bill, so let's start working through the bill. Any amendments on page 1? Any amendments on page 2? Any amendments on page 3? I have a concept that I'd float to see if anyone wants to make a motion on this concept. One of the biggest concerns that's been expressed on page 3, line 8, is that there's no real definition or clarity to reasonable action. And that was, in fact, the real concern that I think was raised by both of our Wyoming companies, is they don't know exactly what standard they have to go to. It's probably not appropriate for us to be specific in statute on what a reasonable action is, but it would be appropriate for that to go through rule and regulation. And through a rule and regulation process, you could look to NIST standards, and you could even evolve over time as those standards potentially evolve. So my suggestion, if anybody wanted to make a motion, would be on line 8 between actions and the word to insert as determined through rule and regulation, and then it would continue on to prevent SIM swapping, etc. or as defined through rule and regulation would probably be more appropriate. So reasonable actions as defined through rule and regulation. And then I would have to check with staff on that to see who would be drafting those rules and regulations, because I'm not entirely sure who the authority in this part of statute would be. Maybe somebody on the committee knows, but we could check with Mr. Hopkinson. It's a thought if anybody's interested in that. We don't certainly have to, but it might provide a remedy. Any motions on page 3? Seeing none. Any motions on page 4? No amendments on page 4. Excuse me, go ahead, Ms. Long.
Just real quickly, Mr. Chairman, I think Christopher Allen's idea of having Wyoming, the state of Wyoming, phasing out SMS-based two-factor authentication is not a bad idea to add to this bill. I would propose an amendment that would require that. We don't have anybody here who can talk about how costly that would be to phase that out over time and use a different authentication metric, but it's an interesting suggestion.
Thank you, Ms. Long. I think if you wanted to make that as a motion, we could potentially conceptualize that motion as a section 2 of non-codified statute, which would require that by some date certain, the state of Wyoming would no longer use any SIM-based two-factor authentication mechanisms.
Yes, I would propose that.
All right.
And let's make it a 3-year phase out. It was so interesting for me to hear that NIST recommended phasing this out 5 years ago, and here we still are.
Okay, so a 3-year phase out. Is there a second for that motion? Got a second from Senator Nethercott. Representative Lindholm, go ahead.
Yeah, thank
on
you,
the
Mr.
motion.
Chair. Yeah, on the motion, Mr. Chairman. I certainly agree with the ideology that SIM-based authentication should be gotten rid of. Absolutely, I'm not gonna support anything that mandates certain uses of different types of technology. I think if a company wants to be to use a type of technology that has been known to cause them problems, then they deserve what they get. It's that
Representative
simple.
Lindholm, just to clarify, it was the state of Wyoming, not a Wyoming corporation, the state of Wyoming.
So the state of Wyoming is not allowed to use SIM-based.
The state of Wyoming government is not allowed to use SIM-based two-factor authentication for any of their programs. So we're just telling our own government what to do. We're not telling a business.
Mr. Chairman, did I miss testimony where we actually got testimony where they used it?
I believe we had that anecdotally, yes.
Mr. Chairman, from who?
I believe, if I recall, and I could certainly be wrong, but if I recall, Christopher Allen suggested that was taking place, and I'm not entirely sure where. Senator Nethercott, go ahead.
Yeah, thank you. So the concept here, I mean, I'm not particularly excited about it either, and I think it's somewhat, ineffective. But it is the driving force of the issue. I mean, I think that's part of the problem, right? So because they're not innovating technology in a way to provide the necessary protections in order to respond to the crime of SIM swapping, we are having to force them to do that, right? Because the industry isn't naturally doing it. And it's resulting in devastation to the free market as a result of the instability associated with the SIM swap to sophisticated users and unsophisticated users. And that's destabilizing to our economy. So, that's the balance that I think has to be struck with our libertarian principles associated with requiring industry to do certain things when they're not acting responsibly themselves. Now, I don't know that telecom, obviously they're not the primary players all the time. There are individual bad actors, but complicity, them being complicit with some of those conduct is also troubling. I don't think we're there yet. I don't think this amendment gets us there. I don't think the bill is there. I think it's troubled waters, but I think continuing the conversation is important until we do get there.
Thank you, Senator. Another cut. Mr. Co-Chairman, go ahead.
Yeah, Mr. Chairman, I'm a no on this amendment. I don't think we should waste too much time on it. I think the appropriator in me is coming out. I would prefer with something like this that we had testimony from ETS on exactly what the state has, what the state doesn't have. And if we're going to phase it out, we would need to have some testimony on what that looks like for the state of Wyoming in terms of cost, in terms of manpower, in terms of alternatives, all of that. I just think it's not necessarily a bad idea. Don't get me wrong. I think that is a good idea. I just think it really has to go through a much deeper process for us to understand what the state of Wyoming looks like and what the cost looks like. And 6:16 at night on a committee without those agencies here to testify, I don't think we should go there.
Thank you, Mr. Co-Chairman. Is there another cut?
Yeah, so just to follow up on my thought, I mean, I think Representative Olson's been doing 2 committees today, so he's doubly tired. But this committee does wild things all the time, which is the reputation of the committee, thanks to the good Representative Lindholm. But, I'm a no vote on this particular amendment as well, even though I seconded it for purposes of discussion. It goes back to the reasonableness standard, right? Which is what the concern. It's not specific enough. And the reasonableness standard is never specific enough. It is unique to the facts and unique to the industry. But it would be, but this would be that element, right? So is it reasonable that they're still limited in the 2-factor authentication, based on industry standards? I think that's a good question. And the answer is probably no, it's not reasonable. And why do we know it's not reasonable? Because of the mass devastation that's happening to American citizens. So I think this is the right space that we're focusing in on, but again, it's not prime time, but telecom's at the table, and that's what this is about.
Thank you, Senator. Ms. Long, going to you.
Mr. Chairman, I'll withdraw that.
All right. Who is the second? Is it okay with the second?
Senator Nethercott, yeah.
Senator Nethercott. All right. So that motion has been withdrawn. We are back on the bill. Are there any further proposed amendments on page 4? Seeing none. Discussion on the bill prior to voting. I know we've had a few people weigh in. Representative Lindholm and then Senator Dockstader. Go ahead, Representative.
Oh, thank you, Mr. Chairman. I agree with Senator Dockstader's sentiment in regards to we've had Wyoming companies that don't want this. The challenge that I would lay out, I guess, is if this isn't the solution and it's something that Wyoming companies don't want, the challenge would be to either Wyoming companies or returning legislators then to find a solution that is doable for those Wyoming companies. And I really appreciated Mr. Woody's comments that he came into it as being against the bill, and now he's not so sure based on the testimony he received. And that's a pretty top shelf company in the state of Wyoming. And so we've got to figure that out. I'm gonna vote to move the bill forward, knowing full well that it's probably not going to make the day. But this is how we make sausage, and maybe it can turn into something and evolve into something that folks can support and get by, where the state comes hand in hand with industry to figure this out for the betterment of our consumers. But we gotta start somewhere. So that's where I'm at.
Thank you, Representative Lindholm. Senator Dockstader.
Thank you, Mr. Chairman. Appreciate Representative Lindholm's comments on that. As I look at this, so the big providers across the nation haven't bothered to get involved in this. Our 2 Wyoming-based companies are showing up and saying this doesn't work for us. Maybe the solution is, as Representative Lindholm said, to work with them a little closer because they have chosen to believe in Wyoming, run their companies here, and employ people and provide services in Wyoming. And they have a more immediate touch than, as I mentioned, than any of the other big companies. There's no 45-minute wait time for either one of these companies when you call in with a concern. So why do we cause problems for our Wyoming-based companies? I'll be a no.
Thank you, Senator. Additional comments? Go ahead, Representative Lindholm.
Yeah, thank you, Mr. Chairman. I just wanted to point out that CTIAA, who testified, does represent those big nationwide companies. I don't know what the deal was there. Normally those larger companies, they've got in-state representation that they normally use. And instead this time they decided as an association to forego that. And so that association does represent those big nationwide organizations, but absolutely noted, Senator Dockstader, and agree with you.
Thank you, Representative Lindholm. And I know that one concept and the reason that the trade organization is representing the interests of the larger companies is that a number of those large companies are involved in lawsuits, and they try not to make any comments themselves under circumstances where there is pending litigation, and instead they ask that those trade representatives provide that testimony. So it's my understanding that in this circumstance, for at least some of those companies, that's the reason why we didn't hear directly from them, and instead we heard from CTIA. Any further discussion? All right, I'll note before we vote that I'm going to be a no on it because I haven't liked the way this bill has been structured, but I want to get to somewhere. So this is one of those topics where if we don't end up moving it forward, I still do want to continue to work on it. And what I'll say on that is I am getting a little frustrated. I'm just about to the point where I want to vote aye because we've seen this bill at quite a few meetings now and last legislative session. We keep asking for solutions over and over again. If not this, then what? That's what we say each time, each meeting. If not this, then what? How do we regulate this? What are the right words? What is a reasonable standard? What are the standards and security that should be there? What's an appropriate level of liability? We have these conversations each time. And each time we reassemble because we want to address those concerns, and folks show up and tell us they don't like this bill. So in the future, if this is the bill that's in front of me, I'm probably an aye vote. But I do want to give it another run. And I think we've got the time based on how the legislative agenda is going to look and the fact that we probably don't have to worry too much about an overly occupied calendar in the near future. So I think this is one that I'll be a no vote on it for today. I might be an aye vote on it in the future. But I want to work with the folks that, Mr. Woody, for example, that made it pretty clear that he wants to engage. And I'd be happy to hear that engagement and put together a better piece of legislation. Final thoughts before we vote? Seeing none, Mr. Co-Chairman, final thoughts? You good? Go ahead.
Mr. Chairman, I'll just be brief, but I'm a no vote as well for a lot of the same reasons you just stated. But I'm not a no vote against solving the problem. When you have committee meetings after committee meetings where you have folks in the public saying there's an issue, and then you have industry coming and saying, well, there's not an issue, at least not an issue with what we do. That's frustrating, especially when the public is saying, well, there is an issue. But the solution, whatever that is, has to involve industry. It's just that's gonna have to happen. And so at some point in time, Mr. Chairman, industry is going to have to recognize that there's an issue. And even more importantly, recognize that there's a Wyoming solution. And I think that's where the real divide is occurring. Is there a federal issue? Is there a state solution, a federal solution? Is there a Wyoming-led solution? I don't know the answer to that, but without industry at the table helping us get there, I don't see a solution. So I was really hopeful that that's what would occur between our last meeting and now. And if industry's not there, then they're not there. They're just not willing to get there. And there's got to be something to get them there at some point. But just pushing a bill forward isn't going to bring them to the table. It didn't last time. So my hope is if these are Wyoming companies and they are Wyoming citizens and they are Wyoming lobbyists, then they care about Wyoming. And they'll help us get to the table. They'll get to the table. They'll help us get to the solution. But I don't think this bill is it. Thank you, Mr. Chairman.
Thank you, Mr. Co-Chairman. Any final thoughts, anyone, before we take a vote? Seeing none, roll call.
Mr. Chairman, this is a roll call vote on 21 LSO 112 version 3. Senator Dockstader.
No.
Senator Driscoll.
No.
Senator Nethercott.
No.
Representative Greer,
Excused.
Representative Lindholm,
Aye.
Representative Yin,
Excused.
Co-Chairman Olson,
No.
Co-Chairman Rothfuss.
No.
Mr. Chairman, that bill fails.
Thank you. And again, thanks working group for the work on this. This is not over. We need to find a solution. And yeah, I don't know what that solution is going to be, but we'll keep trying. Honestly, it put a $10,000 fine per unlawful SIM swap. See how quickly that gets resolved. That's a one pager. All right. Any final thoughts, committee? Go ahead, Representative Lindholm.
Thank you, Mr. Chairman. For everybody that was a no vote, which includes every elected official on this call, I fully expect to see legislation to handle this situation for your voters and your consumers and your Wyoming businesses in the state of Wyoming. And if I can help in any way, I'll certainly make myself available to assist.
Thank you, Representative Lindholm. Other thoughts?
I'll take Representative Lindholm on that offer.
Excellent.
I'm sure he'll bring us a solution.
All right. Well, that's it for our business for today. Thanks, everyone. Thanks to the public that provided extensive, high quality, just fascinating testimony. Good work today, everyone. We start up tomorrow, same time, same virtual place. We've got a few topics and certainly a lighter load, so we definitely won't be going as long tomorrow. Appreciate everyone's time and hard work. Adjourned. Good night, everyone.